certification and also others and such.
Yes, Mr. Pitcher.
My lords, I appear with Miss Cunningham for the appellants Apple, and my learned friend Mr. Moser, King's Counsel, appears with Miss Newen for the respondent, Mr. Gutmann. Now, my Lord Justice Snowden suggested that we address the issue of confidentiality briefly at the outset
Yes.
of the hearing, and I don't know if Lordships have already seen what we said in our submissions about that. Actually, perhaps before I do that, I should just check everyone's got what we need for today. There should be a core bundle, a supplementary bundle, an authorities bundle, then my submissions for today, and my learned friend's submissions for today as well. Yes. So on confidentiality, your Lordships may have seen that the agreement has broken out. I'm not sure there.
So I'll just make sure the submissions for today are the skeletons.
Well, so in the core bundle, you will have seen we have a proper permission to appeal skeleton argument.
Yes.
Tab 2.
Yep.
Separate from that, pursuant to my Lord's direction, we filed it was a 5-pager.
Right.
I don't know if you have that as well. It's just addressing the particular points
yes.
that Lord Justice Snowden raised in his decision in this hearing.
Yes. So on confidentiality, I mean, the concern we have is as to the confidentiality in particular of the matters which are annexed to the judgment.
Yes.
And we're not at the moment clear. I mean, it may be that it's not ultimately for us, but we're not entirely clear as to why the CMA material is confidential.
Yes. So I think I can say two things about that. One is that they were treated as confidential below, and they were
That's not necessarily an answer.
No, of course it isn't. I wasn't suggesting it was, but just for context, they were treated as confidential below. They were ordered to be disclosed into a confidentiality ring. So that's how we kind of got here.
So the CMA were?
Yes, that's right.
Right. Okay.
And the reason why that is so is that was it's a bit like a statement of objections, my lord. So it's not a decision. It was the letter pursuant to which the CMA communicated its provisional views to Apple. Apple then responded to those, and ultimately that led to a decision.
Not drafted like an essay. It has.
No, it's a different procedure. So analytically, it's the same in that they are provisional views for Apple then to respond to, and then having responded to them, what happened next? I don't know if you saw this bit, but is that those proceedings were brought to a close.
I've looked to see what's on the CMA's website, see what else is in the public domain.
So there were undertakings.
There were undertakings given in lieu of enforcement action.
Exactly, and then there was no enforcement action taken. So there never was any concluded view that was expressed by the CMA beyond that. So we actually say that those are subject to, if we need to have the argument, those are subject to an analogous type of protection to Pergan protection that I know your Lordship will be familiar with from the competition regime, because they are only provisional views.
Why does that make them confidential, even assuming they're provisional?
Because they cast aspersions as to the liability of a person who hasn't had an opportunity to test them, in the same way as Pergan protection applies to allusions to liability, even in a final decision of the European Commission in a competition case. So there was a process. It was issued in private. We responded to it, and then the concerns were resolved. And so it wouldn't be right, we say, for those concerns, shorn of their context and their response to them and all of that, to enter into the public domain.
Well, we certainly haven't seen the entire documents.
No.
So we don't know what their context is, and we haven't seen everything else, though a certain amount is on the internet.
A certain amount is on the internet, that's right.
I mean, it's a fairly central part of the judgment of the CAT.
Well, the CAT has itself chosen to put it in a confidential annex, at least for now.
Without hearing any argument.
That's true, up to a point. Obviously, it was canvassed to about this level, I would say, in front of the tribunal. But we say these matters will, of course, be kept under review by the tribunal. The fact that we've applied for permission to appeal seems like an inefficient way forward now to revisit those issues here in this forum. But I've explained why we say they're confidential.
Well, except if there is going to be an appeal,
yes.
You say you should have permission to appeal against the CAT's decision allowing this case to go forward.
Yes.
You say ground 2,
yes.
The CAT shouldn't have done that.
That's right.
One of the main foundations for the CAT's decision to allow the alternative ground to go forward
Yes.
is this CMA letter
Yes.
and the material in it.
Yes.
How do you propose to have the appeal take place without the issue being ventilated as to whether that should be, whether confidentiality should be maintained?
Yes. Our proposal, if this does go forward, is that the letter can, of course, be put in the bundles, in the same way that the argument happened in front of the tribunal. That none of the parties had any difficulty making submissions about that in open court. The issue is when you actually look at what's there, and there isn't actually much more than what's set out in the confidential annex. Like the tribunal has extracted the bits that were most pertinent, and my learned friend has done the same in his submission. And ultimately, the submission about it is that there's nothing behind it. So that there are views that have been expressed, but when you search for the evidence that is the support for it, that there are only provisional views, and there's no evidence to support them at all.
But what we're beginning to grapple with here is a tension between the principles of open justice and transparency, that people who attend hearings in these courts should be able to understand what is going on and what's being argued about, on the one hand, and the desire for confidentiality in certain categories of case in relation to certain communications. And that's not always an obvious outcome for confidentiality.
No, I accept that, my lord. But we do say that one does need to bear in mind the procedural footing of these proceedings as well. So my clients have been dragged into court as the defendants. We're not, obviously we didn't want to be here at all.
Most defendants don't.
No, of course. But we say, and I know some defendants say this as well, not all, but we say we've done nothing wrong at all, and that these allegations are completely baseless, and that there's no evidence for them at all. Our submission, so that's how we got to the tribunal. The tribunal then said, as you'll have seen at the first...
But just pause there. That fact pattern of being dragged into court as a defendant and saying we've done nothing wrong, we don't want to be here, would apply to pretty much every defendant other than one who admits liability or content. So at the moment, there's nothing to distinguish you from every other defendant who has to have their documents and their arguments ventilated in open court.
So I was going to go slightly further than that, my lord, which is to say that our position is that it's not just that we didn't do anything wrong. We say there is no evidential basis at all for the allegation that we did. And that was the context for the first hearing in front of the tribunal, at which the tribunal then said we should go away and provide disclosure of some materials, including that document which we disclosed. And the point of doing that was to check whether that document contained in it any evidence to support the allegations. And if it did, then of course we would be in the same position as every defendant who needs to go on to trial. Our position about the document is that it does not contain any evidence at all of the propositions that my learned friend is advancing. And in those circumstances, we do say it is unfair that we should have not just have to have it handed over and debated in court, but also then have it turned into a public document where, as I say, these aspersions of liability, which we say baseless and never led to anything other than...
Is that on the, what I might call the allegations of the substandard nature of the product, or is it on the conduct allegations? You say it contains nothing.
Well, it contains nothing beyond what is in, but by way of actual evidence of conduct, beyond what is in the public domain anyway. Like the basic facts, which I was going to come on to relay to you of this story.
You may be surprised as to why we're raising this, but it's becoming an issue of broader importance for the Court of Appeal and indeed for the High Court. And it's something which the courts will increasingly have to grapple with.
Of course, my lord. I'm actually not surprised that you raise it, because I accept that it does look a bit odd for the reasons that your lordships have both raised with me. But we say this category of document, which, as I say, is provisional findings, in competition cases, they would always be treated as confidential, as your lordship knows. In fact, there's an absolute right of the Pergan protection.
This was a consumer protection
that's right. But the same
regime which was being initiated.
But the same principles, we say, apply by way of analogy, my lord, because there are aspersions of liability that haven't yet been tested at the stage that they were issued. And then ultimately, if they'd ultimately led to some sort of enforcement action, then...
What is the CMA's view of this?
But they
Or at least let me put a slightly different question. It may be, if this becomes an issue, if there is an appeal which goes forward,
yeah.
this issue will need to be resolved.
Yes.
A little bit more. It will need to be resolved in a way which perhaps the CMA might wish to make submissions on. Would that be right?
They were given an opportunity to comment on it at the time. My recollection is that they left it to us to argue about it, and that that's right, they didn't oppose.
It might be something they will need to address, whether this goes to the Court of Appeal or remains in the CAT.
Yeah.
Because the issue of what happens in the context of parallel regulatory investigations is likely to come up time and time again.
My lord, yes, I'm sure that's right.
Yeah, and it is obviously a matter of some public importance to make sure that the balance is struck correctly.
Absolutely.
And that the word competition just doesn't become a blanket way of getting a confidentiality which is not available to other litigants.
No, absolutely. And your lordships will have seen, I hope, when you look at the bundles as a whole, we have very little material in there that is actually confidential. It's really just this and a couple of other small things. The overwhelming majority of it, including witness statements that Apple internal personnel produced for these proceedings. We've got quite a lot of material in there, which we have recognised. Principle of open justice trumps our legitimate business interests.
But I mean, at some point, it would be useful to have identified what actually we've only got an extract in the confidential annex to the judgment.
Yeah.
And indeed, we don't have, I believe, footnotes 3 to 6 and 15 of the consultation letter.
No. But we have brought copies of the letter in case your lordships would like to see it today. But no, I mean, I can tell you what my submission about those footnotes was going to be, which is that they were all footnotes to Apple submissions, responses to requests for information from the CMA. So they were not contemporaneous documents. And the significance of that is that at the disclosure hearing that we had in between the first CPO hearing and the second CPO hearing, the tribunal had to consider what material we should disclose in order to put the PCR into a position where the PCR would have evidence if there was any evidence. That was the kind of philosophy of the approach that we had. If the allegations were true, let's put in place a disclosure regime that will produce not everything, but would produce at least something. And where the line was drawn for the CMA proceedings was that we did have to give them, PCR, any contemporaneous documents that we had that shed light on the user experience or the impact of the PMF that we provided to the CMA, and we did that.
Can I just ask you, just before we go any further, by the way, is there a transcript of this?
Of what?
Of this hearing this morning?
Oh, yeah, I understand that there is, yes.
Okay.
I believe with permission.
Well, permission was granted, but I don't see microphones and things around.
I believe it's up in the ether based on the live stream.
It's just been done. It's only on live stream, is that right?
That's right.
Yep.
Yes, not physically in the court. But we will need, I think, we'll need a 5-minute break at some point. And yes, I'm just being reminded that the CMA was asked about the letter. They had no objection to disclosure pursuant to the order, and they did not address the position on it becoming public. So we don't have questions from the CMA on that.
But in relation to other matters, more generally,
yes,
you say the regime that the order you want made is where in the bundle. There is I made an order giving you the regime which you asked for, which is essentially to receive notice of anybody who wishes to get a copy from the court.
That's right, and that's in
of various documents.
That's right, and the purpose of that, my lord, that's the order that we want maintained. The purpose of that approach is that if you obviously have the versions that have the confidential information highlighted but visible, if someone applies for production of these documents and we are then provided with notice, we can then give them the versions that have that material and no other material redacted. subject to anything that they might say. Of course, they might say those redactions are inappropriate, in which case that debate can be had.
Yes, but the access to the confidential documents is to any of the copies of the documents held by the court.
That's right. Which contain the highlighted confidential information. Yes. I should add as well that we do need to add one more document now. We need to ask to add one more document now to Annex A, which is Malone and Friends submissions for today, which contain confidential information at the same time. Type quotations from the CMA letter. And we wrote to the court about that on the 3rd of May, again with the agreement of Mr. Gutmann.
Okay. Well, there's probably only so much we can do today. In the sense we've made our position clear,
yes,
both in relation to whatever happens hereafter,
yes,
whether here or in the CAT.
Yes.
But, and we do think the CMA will need to address itself to the arguments it would wish to run in relation to confidentiality of such documents as are going to be used in collateral documents are going to be used in proceedings, because this is an issue, I think, which have greater resonance in the CAT in the future. But issues of confidentiality are ones that we, in the court, are considering more generally.
Absolutely. Yes, we hear that loud and clear.
And just to be clear, I mean, the objection to the matters set out in the confidential annex paragraph 2, CMA letter, is it's not that there's anything, is this right, intrinsically confidential in it, in the sense of trade secrets or anything like that. It's the fact that a view was being expressed.
That's right, yes. A negative view was being expressed by the CMA on a provisional basis in circumstances where that view had not yet had an opportunity to be tested by Apple. Apple had not yet had the opportunity to test those views. And we say it is unfair to Apple to have the regulators' provisional views aired in public.
Yeah, I mean, the context is one that certainly, by my lord, I think reading it doesn't look, although it's described as a consultation letter, it doesn't look like your classic consultation letter.
No, it's a very particular regime.
Well, I think what we're saying, particularly the last few words of paragraph 34.
Yeah.
Now, it is qualified by the word considers. It doesn't say it finds, concludes.
Yes.
But nonetheless, it came quite a long way.
I know that's how it reads.
That's how it reads.
Yes, but that's just if you have the whole document and you look at the regulatory regime to which it relates and the part of the process that we're up to at that point.
Yeah.
That is the position.
Yeah. You want to see it? I think it would be helpful for us to have the whole document. We will obviously be very careful to how we use it, and we're cognizant of the fact that we don't know what the CMA's position is, and this isn't full argument on the question of confidentiality, and we know this CAT itself has said it will have to revisit confidentiality. Of course, the CAT has said it may want material which underlies the...
It already has material that underlies... It has the contemporaneous documents.
Does it have...
All right. But what it doesn't have, my lord, and well, Justice Snowden raised the point about footnotes 3 to 6. You can see them on pages 7, 8, and 9. What it doesn't have is material of that kind, which, as I said, were our responses.
Yes.
So those are Apple-created documents for the purpose of the investigation. setting out Apple's position on the questions that are asked.
Well, okay, so I don't want to cause more problems by having asked for and received a copy of that, but that will presumably have to be added, at least pro tem, to any confidentiality order
Yes.
that we might make pending further argument, more sustained argument on this in whatever forum that might be.
I would, yes.
Yeah.
Okay, move on. Anything else on this? Right, shall we get stuck into the merits?
I think we should provisionally say that we will, we're likely to make an order, presumably, at least pro tem, to cover this hearing, anyway.
Yes.
In relation to I can't remember whether my order was until the conclusion of today, until the beginning of today, hang on. It was until after the oral hearing. So, okay, so
we'll deal with that and any extension.
And we presumably will say that provisionally this letter should be added to the scope of that.
My lord, yes.
Until after the conclusion. Yeah, okay.
Yes, I'm very grateful. So in terms of the timetable, the other bit of homework that your lordship set us was to agree a timetable. We've done that, although it may have been slightly thrown out by the discussion we just had. What we'd agreed was an hour and 15 for me, 45 minutes for my learned friend, and then a short reply for me at the end. But let's see how we get on. Your lordships will have seen that the certification process for these proceedings has thrown up a range of issues for this court. Today, as you know, we're seeking permission on 4 grounds, 3 of which relate to the substance of the claim, and 1 of which relates to the authorization of Mr. Gutmann. Separately, your lordships may have picked up that the tribunal has given us permission to appeal on 3 further grounds that relate to authorization in the context of funding. One of those grounds is what I think we've all affectionately been calling the PACAR point, which is a technical point about whether the funding agreement is still a damages-based agreement. And that's an issue that has also been raised in other cases that are presently before this court. But the parties agreed that it should be stayed pending the potential enactment of some legislation on this topic. But in addition, there are 2 other grounds that we have permission for, which are specific to the funding agreement that Mr. Gutmann has negotiated. And I'll come back to that later in relation to the implications for that for our 4th ground of appeal today. So I really only mention that just to give you the whole picture, the whole landscape, and draw a line between what I am arguing about today, which is our 4 grounds, and what I'm not arguing about today, which is those 3 other grounds for which we already have permission. For the 4 grounds that we are here to consider today, I want to start just by telling you the story of the events that Mr. Gutmann's claim is based on. Because this is one of those cases where you need to hear the whole story, and it won't take too long, but in order to understand why we say the tribunal has gone wrong. And once I've done that, told the story, I will identify the precise points that we challenged in the certification hearing, and the points in the judgment that we say constitute an error of law in rejecting the various strikeout applications that we brought in the tribunal, as they relate to our first 3 grounds of appeal now. Then I will address both on ground 4, concerning authorization. But before I do all that, I just wanted to preview, so we don't keep you in suspense, our answer to the point that my Lord Justice Snowden raised about interrelationship between the 3 substantive grounds of appeal. And as the court will have seen, the tribunal decided to allow Mr. Gutmann's primary case to go forward to trial. This is the subject of ground 1, even though the tribunal formed the view that ground, that part of his case, had no real prospects of success. And the reason why the tribunal reached that conclusion was because the tribunal said that the primary case was interlinked with the alternative case that the tribunal thought was properly arguable. Now, we disagree with that approach, and that's our ground 1. But we do say that in order to consider whether the link between the primary and the alternative cases justifies keeping the hopeless case, the primary case, alive, If we do get to a full appeal hearing on ground 1, we're realistically going to need to take the court through what the alternative case actually is. And the important point for today in relation to, or an important point for today in relation to permission on grounds 2 and ground 3, is that it is really only a very short step from telling you what the alternative case is to making our submissions on why the alternative case is hopeless as well.
Okay, well, this may be another way of saying what you just said to me, but for myself, I would quite like to have clearly identified to me what is the primary case.
Yes.
What type of case is it? What is the alternative case? What type of case is it? And what does intertwined mean?
I'm going to do all of that as I take your lordship through the story.
And that wasn't, as it were, just directed at you. I think that's for Mr. Moses' benefit as well.
No, I appreciate that. So we say that is one reason why it makes sense to grant permission in relation to all 3 grounds, if you're with us, that ground 1 has prospects of success. The other point is this, which is that, of course, if grounds 2 and grounds 3 end up succeeding on the appeal, then ground 1 actually becomes unanswerable. Because on that footing, there is nothing for the primary case to be intertwined with, because the alternative case would have been struck out. And so on that basis, there would have been no reason to retain the primary case through to trial. So that's just by way of preview, so you know what we say about that. That takes me to the story. And it might just be helpful to have the judgment open, just so I'm not going to read it all out to you, but just so that I can point to relevant paragraphs in the judgment as we go. And that's in the core bundle at tab 3, and it's helpful to start at page 44. That's where the first paragraph I'm going to refer to can be found. But, my lords, just to set the scene, the story begins in late 2016, which was the Northern Hemisphere autumn coming into winter. And at that time, the iPhone 7 had just been released. The iPhone 6S had been on the market for a year, and the iPhone 6 had been on the market for 2 years. And it is important to stress that until this stage, it's not said that anybody was having any material problems with any of those devices that is relevant to this case. As time went on, some basic facts of life about battery-powered devices came to have an impact on the world. One fact of life is that as a battery gets older, and especially if it has had a rough life, being used heavily, the battery becomes less able to deliver the peaks of power that it was able to deliver in its younger and sprightlier days. That's one of the facts. The other fact of life is that in cold temperatures, a battery of any age is also less able to deliver the peaks of power that it is able to deliver in more temperate climates. None of this is controversial, and this is recorded in paragraph 7 of the decision that you can see in front of you. So for the iPhone 6 and 6S devices, at this time, in late 2016, some batteries were beginning to show their age, and also were having to cope with the cooler weather again. And at the same time, the demands that an iPhone is called upon to meet also change over time as the technology changes. New apps come
More
out.
apps.
Yep, that's right, new apps, different apps that do different things.
More demanding apps.
More demanding apps, that's right. And also people using those apps in more demanding ways. That's absolutely right. And again, there's no dispute about that. That's also in this paragraph 7, where the tribunal specifically refers to third-party apps like Snapchat, which allowed for, I don't know if your logics have ever tried it out, but real-time filters to be applied when you're on making videos.
We do them all the time.
Yes, I'm sure, my lord.
I think regrettably you probably all know that, yes, my iPhone 7 still functions perfectly well, but presumably because I don't use Snapchat, so you don't.
Well, I don't know whether that's right or wrong, my lord, but I'm very pleased to hear that. But with any battery-powered device, if it happens that you use it in a way and in circumstances where the device demands more power than the battery is capable of delivering, you are going to have a problem. And the way, and I say any battery-powered device, I don't just mean an iPhone, I don't even just mean a smartphone, I mean any device that is powered by a battery. And the way that battery-powered devices like smartphones tend to deal with this problem is that if it arises, they power off. And we call these unexpected power offs, or UPOs, because they're not expected by the user. Because the battery's not dead, it's still got a positive charge. The problem isn't that, it's not capacity. The problem is that the battery can't deliver the peak of power that has been asked of it. So the device essentially shuts down to prevent that causing damage to the electrical. So that's much better, obviously, than ruining your device, but it's obviously still annoying. And again, all of that is uncontroversial too. That's in paragraph 6, just on the previous page. Now, in late 2016, Apple noticed that these UPOs were becoming more common on the iPhone 6 and iPhone 6S devices, not the iPhone 7, which was still new at the time. UPOs were still rare, but they were more common than Apple had seen before. And again, just to stress, this is not because there was any kind of defect in the device. No such defect is alleged now. It's just that the batteries have aged over time and with use, and they were being subjected to more intensive use by some consumers than they had been previously as well. It's a combined effect of all of those factors.
It's not said that a UPO per se is an abuse, nor is it said that a PMF is per se an abuse.
That's right. So
this is about the reaction to them.
It's about the information that was provided about.
Exactly.
So it's specifically about the PMF.
It's a conduct allegation.
That's right.
But it's not, it's not suggested that there was deliberate obsolescence.
No.
Nor that UPOs are per se abusive, nor that PMFs are per se abusive.
No,
We're looking at what happens then.
That's right. It was alleged. It was initially alleged.
We understand that.
Yes,
we understand
that's
that.
gone.
No, we understand that.
Yes.
And that's why my lord was really asking, this is a conduct-based abuse, albeit it's about the effects of the PMF, consequential on the UPO and so on.
That's right. So, although the UPOs weren't anyone's fault, if I can put it that way, Apple obviously wanted to address the problem if it could. And the way it did that was by creating the PMF, to which Your Lordship was just referred. And the tribunal explains that at paragraph 8. And how that worked was that depending on the chemical age of the battery, so how much it had been used essentially, and its state of charge at a point in time, so was it 70% charged or only 30% charged, and the temperature, was it hot or cold, this piece of software would impose different limits on the performance of different components of the device, like the CPU, so that the device would not demand more power in aggregate than the battery was able to deliver, given those circumstances that I've just identified. Now, the first version of the PMF was introduced in January 2017 as part of iOS 10.2.1, and it was a huge success. The judgment records at paragraph 17 on page 46 that it wiped out more than 70% of UPOs for the iPhone 6 and more than 80% for the iPhone 6S. And at that time, in early 2017, there was no uptick in complaints from consumers about their devices running slowly. I don't think the judgment mentions this, but just for your reference, we refer to the evidence on that at paragraph 15.4 of our response to the CPO application, which you can find in Supplemental Bundle, tab 8, page 329. And that was based on data, hard data on complaints that we provided to the PCR. So,
when you say it was introduced and it was a success, it was introduced without fanfare.
That's true, my lord, yes. But then again, one of the odd things about this...
Or indeed any public sort of announcement.
My lord, yes, but one of the odd things about this case is that at its core, that we're coming to the allegation that's at its core, what we have here is a claim that real people, millions of them, who actually had these devices in their pockets.
What I'm trying to do is what, as my lord indicated, is to understand whether your objection to the tribunal leaving in the what was the primary case, if you could call it that, as opposed to the alternative case.
Yes.
Is that that's a technical complaint. It appears to be a technical complaint of a substandard product.
That's right.
Which you say for which there's no evidence, therefore strike it out.
That's right.
Whereas the alternative case, as my lord has put it, is a conduct-based case about how you dealt with consumers and the problem. And my understanding is that you say that is also a case that should have been summarily dismissed or determined. But I just want to understand the type of case that we are talking about when you talk about primary alternative, because I at the moment I think I see them as different types of case.
Yes, there certainly is.
I just want to understand, as I would want to hear from Mr. Moser as well, how they are actually defined.
My lord, yes, we're going to see that in the judgment in a moment. So I'll identify the bit that describes the primary case and the bit that describes the alternative case. And I think that's the fairest way to my learned friend for me to answer the question. So we're getting there. So this is really where I wanted to pause and note, as the tribunal does in paragraph 9, that this is the point in the story where the abuse of dominance allegedly arose, and this is both on the primary case and the alternative case. The abuse of dominance allegedly arose for iPhone 6 and iPhone 6S users, not for iPhone 7 users, because that happened in December, but we're going to come to that. And the abuse for iPhone 6 and 6S users was that, it was said to be that when Apple released iOS 10.2.1, it failed to provide information about what I've called the facts of life, or the physics and chemistry of batteries and the PMF that I've just explained to the court, how the PMF would work and the impact that it would have. So Mr. Gutmann says on both of his cases that Apple should have provided all of that information at that stage. And in order then to have a claim for damages, so that's how he puts his case on abuse, but in order to then have a claim for damages, he needs to go further. And what he says is that if Apple had explained those matters in January 2017, there would have been such a consumer uprising that Apple would have felt compelled by that commercial pressure to make payments to anyone who had ever purchased an iPhone 6 or an iPhone 6S, or alternatively, that Apple would have felt compelled by the same commercial pressure to make free replacement batteries available. And so I'll just show you both versions of that argument in the judgment now. The first one, the primary case, is on page 51. And it's paragraph 28. And this version of the argument is that if the PMF was so bad, if I can put it that way, that the relevant devices were rendered substandard in a legal sense, so that there was a...
What does substandard mean? Sorry, it's really for Mr. Moser, but what does substandard mean? What's the standard, and in what respect is it sub?
So this is what's said in paragraph 28, the way it's defined, is that the quality of the device was so poor that the class members would have had legal rights to obtain redress, for breach of warranty or for breach of consumer law or something like that. They would have, the devices would have been not fit for purpose or not meeting their description or something like that, so that class members actually would have had a claim, not in competition law, but in consumer law.
So can you? The tribunal doesn't do it, but do you get that from one of the extracted paragraphs of the claim form?
My lord, in a way, so I can now show you the claim form if you'd like to see it, but I'm going to give a caveat first, which is that the tribunal makes the point that the claim form is, and I don't mean this as a criticism of my learned friends, but it is drafted in a way that makes it quite difficult to follow.
Well, it's lengthy. It's a narrative.
That's right, and so it doesn't plead with much clarity or particularity how the abuse arises or how loss arises. But I can show you the relevant paragraphs if you'd like to see them.
Some of them are set out in the pleading, in the judgment.
Some of them are, but there is more. There are just a few paragraphs that I would show you if you'd like to see it. So if we open the supplemental bundle at tab 7, and if you go to page 179, So you can see there's a fairly lengthy paragraph 6, which provides at a very high level, but then paragraph 7 says in particular, and at A, we have the definition of battery issues, which turns out to be crucial for what follows. And this is where you can see that what's being said is not that there's any defect in them, but just that they were unable to deliver the peak power required, and that could cause them to shut down. Then you can see at B that Apple is said to have concealed battery issues. Then at C, we have the fact that Apple provides software updates. And then at D, Apple exacerbated the information asymmetry by providing those updates in a misleading and non-transparent way. And PMF then gave rise to what's called the throttling issues. You can see how that's defined at the end of D. And then it's really F over the page, where you can see what's being said in the middle of the paragraph is that Apple's lack of transparency about the battery and throttling issues prevented the proposed class members from exercising their legal rights, whether under warranty protection or pursuant to their statutory rights. So that's what the tribunal then pulled out and said, okay, that's the primary case. That's the case that they're substandard. And the word substandard appears throughout the document. I won't go through all of the references. But then,
and is there anywhere a pleading of the warranty or the statutory rights and a pleading of in what specific respects they were breached?
I think not really is the answer to that. And that was one of the, we'll see that in the judgment as we go through. Basically, the PCR was unable to point to any representations that were made that had actually been breached. But one reason for that is that quite a lot of what Leonard Friends pointed to was really just puffery, lightning fast device, that kind of thing. But also, the claims that were being made by Apple in its marketing materials were obviously about the performance of the device out of the box. No one was making claims that 2 years on in the winter, after you've used your device in various ways, it's going to perform this much faster than some other device fresh out of the box. So there were no warranties or representations that could found any claim at that time. No standard was ever identified. That's what the tribunal says.
But this one of the problems is there's a certain confusion between, inconsistency between the judgment and the CMA letter. They're not entirely at odds with each other. And that's why we're slightly confused about what's meant by substandard, what's meant by legal rights, and so on. I mean, the CMA's provisional conclusion is not entirely consistent with the first paragraph of 41 of the judgment, or perhaps it's consistent with the second part of 41. We have a little bit of difficulty in understanding the tribunal's judgment and how it fits in with the CMA letter. I mean, to be absolutely frank, the reason why we're this is perhaps Mr. Moser concerned with the ground one issue is that it really focuses upon what's meant by substandard. What is it about the facts of the case which give rise to a standard below which there's sub? No one's saying iPhones are anything other than terrific. Fine. We're not saying that UPOs are abuse in and of themselves. They just happen. And equally, PMFs are needed to address glitches and UPOs. So that's, if you like, life in an engineering sense for a product. Yes. But it's how that happens and how that is brought about. And on that bit, the standard is the only standard. I mean, in a sense, using the word standard is slightly misleading. Are we talking about a technical standard, a standard of commercial probity, morality? We're talking about abuse, really, at base. That's the only standard that really matters here. And there are certain paragraphs in the pleading which seem to suggest more of a technical standard. but then it is sort of drafted in the context of the conduct part of the case. And maybe it's a mixture of a certain lack of clarity in the pleading with a certain lack of clarity in the way the CAT itself addressed what was meant by standing. And that's, I don't want to say too much, but I mean, that's, maybe the Mr. Moses is telling us we've got nothing to worry about. There is no case of, if you like, engineering or technical substantiveness. It is all about conduct, and insofar as there's a standard, the only standard is one of abuse, whether it meets that test or not.
Well, the reason it becomes relevant, my lord, is when you get on to, not just as part of abuse, but also when you get on to talk about causation and loss. Because, and this is really what I was just showing you, that there are two ways in which the case is being put. One is that consumers actually had a claim for breach of warranty or something similar like that, because the product was not fit for purpose, or the product was inconsistent with representations that were made. And we'll see that in paragraph 30, the tribunal goes through the representations that the claim that the PCR relied on, which just went nowhere. So that's one case which you can understand as far as it goes. People had claims for the damages, for breach of warranty, and it said that Apple caused them loss by preventing them from understanding the information that they needed to bring those claims. The alternative way of putting the case, and this is the alternative case, is really quite odd, we say, because the starting point is that the devices were fine. The devices were consistent with what had been said about them. They were fit for purpose. There was no breach of warranty or breach of any kind of consumer protection law concerned with the quality of the device. And yet, because 2 years down the line after heavy use, the effect of the PMF was that the device wasn't as fast as it had been previously. Because of that, consumers would have been so outraged by this discovery that they would have put pressure on Apple, and Apple would have caved into that pressure and made ex gratia payments. That's really
taking out any question of outrage, that's not a million miles from what the CMA said in their provisional conclusion.
They don't actually say that last bit, and in addition, there's just no evidence for what the CMA says. That's why we went through this process. We go around in circles here, because there's, I think our concern is, one, there's a lack of clarity in the pleading as to precisely which standard we're looking at, and there's a certain lack of clarity in the judgment as to precisely which standard they're looking at. Well, shall we go through that, because that's really what I was just about to be taking you through, I think. So, as I say, paragraph 28 actually is, we say, clear as to what the tribunal understood PCR to be saying in relation to standard, which is that there was some flaw in the devices, in the effect of the PMF, was that class members actually had legal rights to obtain redress by way of financial compensation or battery replacement. So that is one way of putting it. The other way of putting it is on page 34. This is the alternative case.
Paragraph 34.
Sorry, paragraph 34, page 52.
Yep.
Where he says that PCR's case was not dependent upon members of the class having an entitlement in law to compensation. He submits that the lack of transparency could give rise to abuse if the PMF impacted performance, notwithstanding that this did not give rise to a breach of warranty or consumer law. If consumers had full knowledge of the impact of the PMF and were dissatisfied, Apple would likely have had to respond to consumer pressure, even in the absence of a legal correct claim. And that is really the subject of our strikeout application, summary judgment application for ground 2, which I'm going to come on to. But those are the two ways in which the claim is put, and it's primarily relevant, and this is a matter that wasn't within the CMA's domain, if you like. It's primarily relevant for the argument on causation and loss, which is what we're applying to strike out in ground 2. So if I can just park that for now, I will obviously come back to it, but I'd just like to continue the story because the rest of it is relevant too. So unsurprisingly, by late 2017, the same thing was starting to happen to the iPhone 7 devices, which were by then a year old. And so Apple introduced a further update, iOS 11.2, which extended the PMF to the iPhone 7. And that was at the beginning of December in 2017. And of course, by then, the iPhone 6S is 2 years old and the iPhone 6 is 3 years old. So those batteries were deteriorating further. And of course, winter was coming again. And so the consequence of that this time wasn't UPOs. The consequence was that the PMF obviously started to bite a bit more, as it would inevitably do, given the passage of time. And there were rumors at the time that Apple was deliberately slowing down older models to force consumers to upgrade. Those rumors were completely false, and that they're not advanced in these proceedings at all. Indeed, the irony is that what the PMF was is a software innovation that extends the life of the phone by preventing it from UPOing every time that this problem arises. But those rumors were obviously toxic to Apple, and so Apple addressed them at the end of December. So just over 3 weeks after the PMF was actually extended to the iPhone 7. And it did this by providing a full explanation of how batteries work and how the UPO problem had arisen and how the PMF operated to prevent them, including the fact that they would have the consequence of slowing down the devices in certain circumstances. As well as that, Apple apologized for not having communicated about all of this more clearly earlier and provided a discounted, but not free, battery replacement program as a gesture of goodwill. Now, we have a copy of what Apple said at tabs 5 and 6 of the supplemental bundle. I don't have time to go through it all today, but I would just draw your attention to one piece of it, which is in tab 6 at page 174, where what you have is an enumeration of the various effects of the PMF that users might experience as their batteries age. You see that in the bullet points at the top of the page. So that is what Apple did at the end of December 2017. And all of this was very big news at the time. And I don't just mean in the trade press or in Reddit or anything like that. I mean international news, like the BBC is reporting on it. And the key point, for the purposes of my submissions, is that nobody has ever identified any specific information that Apple did not make available to the public on its website at that time. And when I say nobody, I'm including Mr. Gutmann in that. That there are no facts that are alleged to have been concealed after this point. It's not said that there was some other effect of the PMF beyond the ones that are enumerated here. So the one final piece of the story that I need to tell now is a survey that was actually conducted on behalf of Mr. Gutmann in December 2021. So that's 4 years after Apple's message to its customers, and almost 5 since the PMF was introduced. And that survey, you won't find a discussion of this in the judgment, Lords, but that survey was conducted for the purposes of putting this litigation together. So he, or the people working for them, chose the questions that they wanted to ask in order to elicit the evidence of consumer harm that they would then need for their case. And what's really great about that survey is that at the time Mr. Gutmann put it together, he seems to have thought that the PMF applied to the iPhone 5 as well, so not just the iPhone 6 and iPhone 7. And so he gathered together a group of people who had the iPhone 5 and the iPhone 6 and the iPhone 7, and he asked them questions about their recollections of their experiences with their various devices. And he wasn't just asking them in general, he was asking them leading questions, specifically including whether they remembered their devices slowing down after updating their software. And the results of the survey are recorded in our skeleton, which is page 32 of the core bundle. Paragraph 44.2. And what's interesting is that the overwhelming majority, so that's 76% for the iPhone 6 and 79% for the iPhone 7, had no recollection of their iPhone slowing down after updating the software. And what's more, the proportion of iPhone 5 users who remembered their devices slowing down was higher than the proportion for the iPhone 6 or the iPhone 7. And so what that tells us is that the proportion of users who remembered having this experience was actually lower for devices that had the PMF than it was for devices that didn't. And we say that that is really why the case on causation is hopeless. We say we did tell the world about the PMF in December 2017, so albeit belatedly. If anything, that was a more fraught time to provide that information than January 2017 would have been, because in December, the announcement was in the context of false rumours of deliberate slowing down of the device. And so it had to be an apology for the fact that Apple had not explained this earlier. And it was also at a time where the iPhone 6 and 6S devices had got to the point where the PMF was noticeable for some users, and hence the complaints that led to the rumours in the first place. And yet, even in that context, there was no commercial pressure sufficient to drive Apple to provide ex gratia payments or free batteries. Instead, what Apple did was provided the information and introduced a discounted battery replacement program, and that was that. And the sky didn't fall in. Everyone just moved on, understanding the way things worked. And so we say there is just no reason at all, not just balance of probabilities, but there is just literally no reason at all that has been advanced as to why Apple would have done anything more if it had provided the same information 11 months earlier. And that's not something you will find addressed in the CMA material, because as I say, the CMA doesn't have Mr. Gutmann's problem. The CMA is not concerned with this issue. And similarly, there's even less reason to think that Apple would have done anything more if it had provided that information 4 weeks earlier, in the case of the iPhone 7. And it's not just no reason to think. There is actually no evidence at all to suggest that Apple would have done more. And by evidence, I mean that in the broadest possible sense. So it is not even the case that any of Mr. Gutmann's experts have opined from any field of expertise that, given the circumstances, Apple would have felt compelled to do this. This is all just put as a matter of pure speculation on the part of Mr. Gutmann. And we say it's pure speculation that just makes no sense in light of the basic facts that I've just outlined. And that, in a nutshell, is what we said to the tribunal last year. So I just note that my learned friend says that we didn't run that point as a strikeout. That's wrong. And if I could just give you the reference to that, it's in the supplemental bundle, tab 8, page 307, and paragraph 67, where we expressly say that this case on causation is liable to be struck out for the reasons that I've just given. So that's the story. The procedural context, I think we've essentially covered, in that there was the first hearing, then there was the disclosure process. And we do say that disclosure process is very important for the analysis of the strikeout applications that then followed. And so I just want to show you very briefly what we were ordered to disclose, so you can understand the submission that I'm making, which is that if there were any truth to these allegations at all, something would have turned up in that disclosure process in order to support these allegations. So that's a submission, and I'll show you what was ordered to be disclosed. Supplemental bundle, tab 4, page 163. In paragraph 1a, there is a reference to technical reports and/or key summaries created by Apple in the ordinary course of business and disclosed in the US litigation. And that's an important piece of context, because not the same claims as are now advanced by Mr. Gutmann, but the claims concerning the same basic factual story had already been litigated in the United States, and material had been disclosed. And what we were ordered to do was to talk to the US lawyers who had been running that litigation and obtain from them any technical reports or key summaries meeting that description concerning the impact of the PMF and also user experience. And the point there is that if what Mr. Gutmann says is true, so if the impact was either so great actually as to render the devices substandard in the sense of actionable, or if the impact of the PMF was so great that there would have been a consumer outrage, an uprising that would have put pressure on Apple to do something extraordinary that it had never done before, if either of those things were true, you would expect that there would be some internal Apple document supporting their knowledge of that fact. And that is the type of document that you would expect the US lawyers to know about. And so, although this process, which wasn't a full search process, wouldn't have produced every document that supported Malone and Friends' case, if there were any documents that supported Malone and Friends' case, at least one of them would have turned up. Then, I just want to draw your attention to, over the page D, I'm not going through all of them, but technical reports or key summaries for the same types of documents that Mr. Crumlin was aware of. And that is significant because Mr. Crumlin was the senior Apple director of iPhone system integration who ran the process of creating the PMF. So again, if there were documents showing that Apple knew it was creating devices, it was rendering its devices substandard, no longer a premium phone, inconsistent with its warranties, or more generally, liable to create the kind of terrible user experience that would prompt, that would allow Malone and Friends' case on causation to have some legs, then again, Mr. Crumlin would have known about that. Maybe not all of them, he couldn't have recited all of them, but he would have known that, and we would have had to produce it. Then at 2A, you can see that we were required to provide them with all of the, summarize it as contemporaneous documents on that topic that we provided to the CMA. And for this one, I emphasize that it wasn't just that someone is aware of, it was all of them. And then at 2B, we had to provide the consultation letter, which is the one that I've already addressed you on briefly, including any accompanying annexes or exhibits as well. So if there's anything that the CMA produced to support its provisional findings that are set out in that letter, then we had to provide that as well. So that is the procedural context for the submissions that I'm about to come to.
Why is it that, if that's right, why is it that the CAT seems to suggest at the end of 42 that it was, quote, apparent from at least footnotes 3 to 6 and 15 of the consultation letter,
yes,
that Apple provided information to the CMA in relation to this matter which the PCR has not yet had the opportunity of reviewing.
Melo, that's right. So that's what I said to you at the outset about those footnotes. What we were ordered to provide was the contemporaneous documents, as in Apple's business documents, its emails or anything like that that recorded its internal view that had been provided to the CMA. What Apple was not ordered to provide was its responses to RFI, so documents created for the purpose of the CMA investigation, whereby Apple explained to the CMA Apple's position on the matters that the CMA was asking it about. Now, you can understand, I hope, why the tribunal might have thought it wasn't necessary to disclose those, because if it's the case that there are literally no contemporaneous documents that support the propositions being advanced, that these were terrible devices, that the PMF rendered them just awful consumer experiences, then it seems, and if Mr. Crumlin, who provided 2 witness statements to the tribunal explaining how this was all done and what he thought of it, all of that.
Sorry, just let's be clear, is the category of documents referred to by the CAT at the end of paragraph 42 of the judgment,
yes,
is those those which are effectively referred to in the footnote 5 to the order?
Sorry. Yes. Yes, your Lordship has the point.
So is this right? The CAT says there's some possibility of relevant material being disclosed in ongoing proceedings because we excluded that category of documents from the disclosure which we actually ordered.
That's right, my Lord. Yes.
What was the point of ordering,
Well,
of excluding that category from? I thought the whole purpose of the order was so that any relevant
my Lord, yes.
disclosure could have been
Exactly.
reviewed.
My Lord, I hope your Lordship will forgive the tone of frustration in my voice, but I stood there in that hearing having the argument about what the scope of it should be, all with a view to doing what your Lordship has just said, which is the only rational thing that could be driving a disclosure process.
So where did that exclusion come from? Did you suggest it, or did somebody else suggest it?
We suggested it. So we said that the sensible way forward.
Okay, so you actually said, well, we're not we do want to carve out of the category of documents to disclose. So you've been sort of hoisted by your own petard now.
Well, my lord, no, because I didn't have a veto right. So what happened was I made the argument to the tribunal that if there are any documents that support their case, that they will be contemporaneous documents that record what Apple thought at the time. And if I can just explain why that's the case. If there are no contemporaneous documents that show any awareness on the part of Apple that these were devices that were substandard or in other respects poor, and given Mr. Crumlin's views, which are set out in the witness evidence that has been provided to the tribunal, it really beggars belief that Apple would have said voluntarily in submissions to the CMA that, oh yes, Mr. Crumlin is quite wrong. These devices were terrible. That just doesn't make any sense.
The target of your challenge has to be the CAT's conclusion that it's going to defer all of this pending disclosure. It might come back and strike out the claim after narrowing. They made this very clear, I think, in paragraphs 60 and 73.
Yes.
And so we've got to be able to be absolutely clear that making that case management decision involves an error of law, because it may agree with you.
Yes.
When it comes back, and if you're right on disclosure, it could well do so. On the other hand, we've got the CMA consultation paper and the relevant paragraph cited in the judgment. We've now got the decision. And just looking through the fuller decision, there is other material which explains why the CMA came to the conclusion in the bit cited. I'm particularly looking at paragraphs 21 to 25 of the decision. So for us, the choice is this. We've got to conclude that the CAT erred in law in deferring the matter for you to have another crack after disclosure. So the only difference is really one of disclosure. We've got the CMA decision. We know they take a different view, including one on causation. They may be absolutely wrong. It may be clear from disclosure given later that there's no errors. But you've got to persuade us that the CAT was wrong to take a case management decision.
That's right.
Today you need to explain you have a reasonable prospect of success.
Yes.
That's exactly.
Yeah.
But if we were to do that, we then got to consider, do we just simply say, hands off, this is case management? Why is it that the case management decision that they've taken, which is not necessarily adverse to you, it simply puts you to the burden of completing disclosure,
yes,
involves an error of law,
yes,
which we can interfere in?
So the critical point, which I think is missing from your Lordship's summary of where we are, is that the CAT found that this primary case of substandard performance is actually unarguable. So I do need to show you that, because that then sets up the submission that I want to make. So it begins at paragraph 29 of the judgment on page 51, where the tribunal addresses the distinct argument that the devices were substandard in the sense that we've discussed. And what the tribunal says is that the PCR, which is around the middle of the paragraph, the PCR has been unable to explain with any particularity what the relevant standard should be. Furthermore, it cannot be assumed that because a phone is slower, measurably slower in some circumstances, it is substandard. Such a case requires articulation of the expected standard.
Is that still the PCR's case?
Sorry, I'm missing where you
29, paragraph 29.
29, sorry.
Yes.
I mean, because...
Yeah, my lord, it is.
But is that... I'm just looking at...
They were tested on this at the hearing, so this reflects the upshot of much debate between my learned friend and the tribunal, where Mr. Turner in the chair pressed my learned friends on what standard they could identify. And we go on to paragraph 30, my lord. You can see some of that is recorded here. They referred to two documents. The first was a press release, which made reference to blazing fast performance. And what the tribunal is saying is that they doubt that that assists in setting a standard to which devices could be said to fall short. Then paragraph 31, then it said that there was another press release which made reference to Apple's third generation chip producing a 70% faster CPU and 90% faster GPU. But, and this is the point I was making to you before, that's not a representation that the affected phones are actually faster than the iPhone 5, but is referring to improvements over the iPhone 6. It's also not a statement about how the devices would perform 2 years down the track. It's about how they perform like for like, both devices out of the box. And so paragraph 33 has the conclusion that the PCR has not at this stage of proceedings been able to put forward primary facts which lead us to conclude that it is a reasonable prospect of success. That is the strikeout test.
Well, they also say at this stage.
That's quite
we
right.
understand your position is on the basis of what they've actually held. It's illogical to then say that at least that part of the case can go forward. And we understand that. And that's really what we're concerned about. What is the logic of the case? How do we construe this judgment?
Yes.
I mean, I find it quite difficult to understand where it transitions from one to the other, and which is the boot and which is, being pulled up by the boot.
Yes, I mean, that reference to at this stage of the proceedings isn't grounded in anything that's gone before, as I see it at the moment. And I can't at the moment immediately see what reference in the subsequent part of the judgment could be to explain what primary facts are going to come out at any later stage of the proceeding. The only thing that seems to suggest that is paragraph 42. But that's dealing with as I would understand it, that's dealing with a different thing.
Yes, and that's right, my lord. And then at paragraph 43, they continue, and they say, notwithstanding that we've not been persuaded that on the materials before the court there is a reasonable prospect of establishing this at trial, it appears that the question of whether they fall short of a legally relevant standard is intertwined with the general allegation.
Right. Why intertwined? I mean, it'll be obviously Mr. Moser to suggest this, but what do they mean intertwined? Or do you say there is no intertwining?
Yes, my lord, we say intertwined is not a good word for the true position. The true position is that there are two allegations being made, and one is a more extreme version of the other. So one is the alternative case, if I can start with that, is that the PMF had an impact, a noticeable impact, on performance of the device, and that it was a sufficiently large impact that it would have made consumers upset and sufficiently angry to put pressure on Apple to grant redress. So that's the alternative case. The primary case goes further and says no. The effect of the PMF was actually bigger than that. It was so big that these devices were no longer premium devices, or however my learned friend wants to put it, so that Apple was actually in breach of warranty, and they've never identified a satisfactory warranty that we could have been in breach of, but you get the point.
So does it turn on the magnitude of the effect of the PMF?
That's one half of it, and then the other half of it is whether they...
That's how you describe the difference between the two cases.
That's one half of the difference. The other is the establishment of some kind of standard that they were capable of falling short of. So some warranty or representation that they were inconsistent with.
So is your attempt to strike out the primary case and your complaint on the ground one of the proposed appeal, that the sort of technical question of whether there was a standard which was breached should be taken off the table, and the CAT should have taken it off the table because there's no basis for thinking that something will turn up?
That's right, my lord, and I go slightly further than that, because I understand why my lord Lord Justice Green says, well, what's the harm in just ploughing on? Let's see what happens.
No, we don't say that. I'm just working out what the difference is. I mean, disclosure is burdensome, costly, etc. But I mean, the gist of my concern is the CMA decision, in which they do, in paragraph 33, which is cited, they don't rule out the possibility of there being warranty claims or other statutory claims. They don't. I mean, you may say it's nonsense, but
I do say that, and I say that for a particular reason, my lord, which is that we had to provide the PCR with any evidence that was underpinning that, other than our own submissions to the CMA. And the point of that process, as my Lord Justice Snowden says, the whole reason why we went through that disclosure exercise.
I understand that. That's the clash, isn't it? I mean, but we have the CMA saying one thing and you
It's a
saying
conclusory
another.
statement, my lord. It's
Sorry?
It's a provisional and conclusion. So there's no reasoning to support it, my lord.
Well, we understand that. It is what it is.
So that doesn't provide, like, the mere fact that someone
Does
had...
that permit the cat to strike it out when you've got that there? Whether it's good, bad, or utterly indifferent is another matter. But there it is.
Yes.
Is that a strikeout matter?
We say it is. I mean, the tribunal had, up until this point, before it got to the case management point about intertwining, applied the correct test under easier, which is to say whether there is any reasonable prospect of something turning up at trial.
So, I mean, and to be specific, I mean, if you say the cat was wrong
Yes.
and you win,
Yes.
which paragraphs of the amended particulars of claim, or which bits of them go? Can you just give us an illustration of what you say must be struck out?
Yes.
So assume you fail on ground 2 for the moment, because if you win on ground 2, everything goes.
Everything.
So assume you win on ground 1 and fail on ground 2. Can you show us what goes? What difference does it make?
Yes, I'm not going to show you everything that goes, but I'll give you an example.
Give us
that's okay.
So we can understand the importance of...
Yes. So if you go back to, this is what I was showing you before, but if you go back to the supplemental bundle, page 181.
I'd quite like to do it also by reference to the actual pleading as opposed to the summary overview, which
I'm just getting a reference, sorry.
Yeah.
It's just...
show us it in the summary and show us it in the main body, if you like.
Sorry, in the summary, it was paragraph 7F.
F.
F. Which is on page 181, and you can see the bit in the middle there where it said that our lack of transparency deterred or prevented the proposed class members from exercising their legal rights, whether under their warranty protection or pursuant to their statutory rights. And then...
So wait a minute. So which bits are you saying get taken out?
So that bit, the deterred or prevented the proposed class members.
So you'd say after the word install relevant to iOS upgrades, you'd say that's as far as it goes. The rest of that sentence goes out.
Correct.
But you accept that the words Apple did not voluntarily offer such redress.
Yes, there would need to be some wordsmithing, but yes, there's no such. But yes.
Yeah.
That's right. The rest of it is the alternative case. And I believe at page 240, paragraph 158, we have...
Sorry, page 240 of the bundle.
That's right, of the supplemental bundle.
Paragraph.
150A.
Okay, we seem to have slightly different.
Oh, really?
158 to
158. I'm so sorry. Yes.
Oh, that's right. It's the same words. Yes.
So you strike out the words in green.
No, it struck out the impeded or deterred them from exercising their legal rights, whether under...
I see, yeah. So impeded or deterred them from exercising their legal rights.
And do you strike out the highlighted reference?
Yes. Yes. And then also throughout the document, you'll find references to substantive. So there we go as well. I think there's one in paragraph 2, for example.
So standard in this context is the legal right.
That's right.
That's all it means.
That's right. But that's the way the point developed at the hearing.
So either warranties or other statutory rights.
That's right.
Sorry, maybe because of the hanging, I'm missing. Sorry, have you gone back to paragraph 2, you said?
I did. I mean, this is a less important point, but yes. So in paragraph 2, so that's on page 177. See, there's a reference to substandard performance. So that and similar references, just because of the way substandard has been used, would also need to go.
But you understand that again to be warranties or other statutory rights.
That's right. We haven't had any other standard, as the tribunal explains in paragraph 30. It's really for the PCRs to tell us what the standard is. It's not my job to tell them what the standard is. If you're going to make an allegation that something is substandard, you need to say what the standard is and why it's sub.
Right. Anyway, your understanding is that it is those two rights, statutory rights or warranties.
That's right. That's my understanding. They do sometimes say, render the device no longer a premium
we understand,
device.
but we're not talking about engineering standards or anything like that.
No.
We're just talking about something which is narrow and legal here.
That's my understanding.
So that's what you said their primary case was.
Yes, that's right.
And then that just leaves their alternative case, which is even if there were no statutory rights or contractual rights,
Yes.
there is nonetheless an abuse because.
That's right. And your Lordships, I hope you've appreciated that what we're attempting to strike out in relation to the alternative case.
As you say, there's just no causation.
It's the causation,
yes.
right? But there is also, so that's ground 2. There is also ground 3, which relates to the period after December 2017, where we say the abuse stopped.
But on that,
Yes.
the CAT said, look, it's not just a question of there isn't any other fact that it hasn't been said that you ought to have made known. The question is whether what you did by way of an announcement was sufficient to stop the effect of what you had previously done. I paraphrase, but that's their assessment, and they say that's just not something we can determine summarily at this stage. It's not simply show us something we didn't say. It's how do we know that the way you said it was sufficient to kill the effect in the marketplace?
But, my Lord, yes, that is what they say. And our answer, and so that's in paragraph 48 of the judgment.
Yeah.
Just while we're here, perhaps I should just answer that now before I come back to the others. So they say that the extent of dissemination and how consumers would have understood the message and responded to it requires evidence. Now, the response to that is to ask the question, why? Because we know that this material was plastered all over the news and all over the internet. So anyone who experienced in their pocket, and this is what is slightly maddening about this case, is that the allegation is that millions of people were wandering around this country for quite some period of time with devices in their pockets that they were having terrible experiences in. The oddity about that is, of course, that if they were having bad experiences, that's something that they would have known. And of course, if that's right, and if it's something that was so bad that they were so angry that there would have been consumer uprising capable of causing loss, then you might have thought that you would have done a Google search for iPhone slow performance. If you did that, my lord, it is just inconceivable that you could fail to find this information on the internet. Even the single worst searcher of information in the universe could have found this information. It's astonishing to suggest.
So what's your criticism of the CAT? Is it irrationality that no reasonable tribunal could have taken the view that it required evidence at trial? I mean, what's your legal objection to the way the CAT decided to deal? Because this is on the assumption, let's get this right, that one or other or both, well, it must be actually, either or both of the ground of the primary alternative cases has some legs.
Yes, that's right.
And you're saying, even on that assumption, no sensible CAT could possibly have thought that what you did wasn't enough.
My Lord, yes. The only edit I would make to the way your Lordship has just put it is I would delete the word even and replace it with especially on that assumption, right? Because on the assumption that everyone is having this terrible experience, they're going to find out about it. It was plastered, like I say, it was plastered all over the news. You can still find it today. You really would need to have been sitting under a rock and therefore receiving no cell phone signal in order to find yourself in a position where you didn't know about this. My learned friend characterized it as significant media attention. So we just say that there is, if you ask yourself the other question, which is, what is it that you're expecting to find at trial that is going to shed any light of this? I mean, of course, I can't say that every consumer read what was written there on the website, or read it and understood it. No one is ever going to be able to produce evidence from that at trial. We're not going to have witness statements from millions of consumers. So what is it that is going to be there at trial that isn't there now? One sometimes gets
remember what we've got to do. We've got to grant PTA upon the basis that at full appeal you might establish that their decision now, which is case management, is irrational. Because the cat would pull around and say, well, you could well be right, in which case we will strike it out after disclosure. That being the only difference between the two positions, after disclosure. And I understand why, quite legitimately, you may wish to avoid that.
My Lord, yes. And that actually provides me an opportunity to say what I was about to say before about ground one, which is the ground where the tribunal is with us, that the claim is hopeless and there's not going to be anything at trial. And this is your point that, well, so what? Just do disclosure and then come back and do it again.
But if you're right that logically that's what they've said, then we understand the point. Yeah. If you're right that they've said there's nothing in the broad way in which the abuse is put, then logically our concern is they ought to have the courage of their convictions and just do what naturally follows.
It's more than that, my Lord, because it's actually not just the courage of their convictions, it's performing their duty as a gatekeeper.
I'm being polite, but it would be an error of law not to follow through with a finding.
Exactly.
If that is a clear and equivocal finding, and it's not intertwined, then the logic is it should be struck out.
Yes.
And that's just almost a matter of, a 1 + 1 = 2.
Yes.
If 1 + 1 is correct, if those two earlier propositions are correct.
Yes.
If you're right that that's logic, then we've got no difficulty with the end conclusion.
And my Lord, that's how we have always read the tribunal's judgment. And if that is wrong,
what in practical terms does it take off the table, do to the proceedings? How usually when you're doing this sort of exercise, there's some clear indication that taking that allegation off the table will shorten the trial, shorten the process, save money, etc., etc.
No, my Lord, we say it actually goes beyond that. It's not just a simple matter of those kind of practicalities.
Well, no, I'm asking you to make good on those practicalities before you go on to the next step. What does it actually do?
My Lord, what it removes from the case is the inquiry as to what the standards are. So what does a device need to do in order to be not substandard? And then it removes the question of whether they were or weren't.
So
that's not my strongest point, my Lord, being frank about it. My strongest point is that it is wrong in principle for my clients to have to suffer the PCR standing up in court and saying things repeatedly which get reported in the press, which if said outside the courtroom would be defamatory. And it is...
Well, setting aside the last bit, we understand the former. We understand, and as a matter of law, if you're right that the judgment makes a clear and equivocal finding that the broader abuse does not wash even at this stage, then it seems to us logically there is a consequence. That's all you need to say.
Yes, but my Lord, if we're wrong about that, so this is an argument I don't think I've detected before, but that the tribunal wasn't saying that the primary case was hopeless. If I'm wrong about that, then we certainly would be saying that it should have said that the primary case was hopeless, because there was absolutely no evidence capable of supporting it. Particularly in view of, you remember I told you about the Yonder survey, the survey
I understand. I mean, the difficulty...
And none of that is addressed in the judgment, my Lord.
I mean, I understand your former point. For the latter point, it just seems to me, and again, I'm looking through the CMA decision, it's difficult to strike out something in which you may have maybe utter rubbish,
Yes.
but you've got it. And the tribunal simply saying, well, let's see disclosure, and then we'll have another go.
Yes.
And we may then strike it out, notwithstanding the CMA, because so that's the target,
I
which is
understand.
not an easy target.
I understand that as well, my lord. Obviously, appeals of this kind, particularly from a specialist body, are always difficult. We're very
Case
cognizant.
management.
My lord, yes.
But if it's illogical, then that puts it into a different.
And that is where we say
Yeah,
it is
we
for the
understand.
reasons that I've developed.
We are conscious of time, and we're battering you with questions. We understand. Why don't you try and pull the threads together? Because we've got a pretty good idea of what your case is.
Yes. So, my lord, just pulling the threads together then on grounds 1 to 3. On ground 1, what we say is that the error of law was that the tribunal did apply easier. It was well aware of the easier principles, which they're stated in the judgment. And it reached the conclusion in, I think it's paragraph 43. No, it was before that. It was paragraph 33. That notwithstanding all of the evidence that was available from disclosure already, there was no realistic prospect of success at trial. And we say the tribunal should have gone forward and struck it out. In relation to ground 2, what we say is, again, in light of all of the evidence that are just summarised for your lordships, it is just fanciful to say that at trial something will turn up which will support the PCR's case on causation. And the error of approach that the tribunal fell into was having identified the outstanding uncertainty, which was as to, this is a paragraph 36, as to the impact of the PMF in practical terms on users. Having identified that uncertainty, the tribunal didn't go on to ask itself, well, where would evidence of that kind be? In whose head is it? In whose documents is it? It's an uncertainty about the lived experience of members of the proposed class. And again, the tribunal failed to consider, in light of the evidence, or failed to explain, in light of the evidence, why there was any prospect that if people in 2021 couldn't remember having had any problem, in the PCR's own survey, on what basis is it said that there was a problem that is so large as to cause the extraordinary effects that are alleged? That's ground 2. Ground 3, I think I've just covered for you anyway, so I don't need to repeat that. Ground 4, I haven't addressed you on yet, and so I'll do that now if I may. I am conscious of the time. The 4th ground is of an entirely different character. It concerns authorization. The statutory test is in Rule 78, which is authorities, tab 14, page 402, just for your reference. It's very simple. The test is whether it is just and reasonable for the applicant to act as a class representative in the collective proceedings. Our objection to Mr. Gutmann is that he is someone who has no legitimate interest in the subject matter of these proceedings. And we say, particularly in circumstances where the core of this case, not every case, but this case, is always going to be the question of the lived experience of consumers of the relevant iPhones, we say it is wrong to certify someone who is effectively just a professional litigant, or to use the word, I don't mean anything pejorative by it, but effectively a busybody, someone who doesn't have a connection to the issues.
Why does he need to have owned an iPhone 6 or 7 to do the right job for consumers?
I don't say that, my lord. So we don't say that it's essential. That we said that that's one way someone might have a connection to the issues if they'd owned the relevant device and experienced the things that they allege. That's one way. But we don't say that that's an absolute requirement. He's also not an academic who works in any field that is relevant to the claim. He's also not the leader of some group, consumer group of aggrieved iPhone 6 and 7 users. He's just an individual who has no connection at all with any of the events, even after the fact, with the claim, who is putting together a portfolio of interesting competition claims to run.
And he might be quite good at it.
And he may well be quite good at it, my lord. We don't. We're not making a point about his.
Make him unsuitable.
Well, we say that it, and I want to show you very briefly the government consultations on this, because we say that the point that we're making here about his connection to the issues in the claim is a point that fits under this rubric of what is just and reasonable. So I will show you that. It's in Authorities, tab 17. I just need to run through page 440. So this one is part of the, just to give you the context, it's part of the government's response to its consultation on the creation of the class action regime.
Which page?
Page 440.
Not in my tab 17. It's. Have you got an internal page number?
Page 32.
Page 32.
Ours are not sequentially numbered. They're numbered. The bundle seems. I don't understand it. Yeah, the bundle seems.
But page 32 is what?
Public or private opt-out?
Public or private opt-out, yes.
So your lordship has it. Does.
Yeah. Okay.
I'm sorry about that. You can see questions 22 and 23 at the bottom of the page. The debate was whether class actions should be limited to public bodies like the Competition Authority or should be open to private persons. And if so, whether it should be limited to class members and genuinely representative bodies or should be extended to law firms and funders and such like. And if you go over to page 442, just to cut to the chase, you can see the government's response to this. So paragraph 5.30, the government decided that it should be open to private parties to act as class representatives, but there was a risk of abuse if law firms, funders, or SPVs could bring cases. Only those who have a genuine interest in the case should be able to bring claims. And that's then reflected in the decision that was made at 5.32. So the next question your lordships might ask me is, why don't the rules say that in terms?
But 5.32 doesn't talk about individuals. Mr. Gutmann's neither a law firm nor a third-party fund. He's not an SPV.
That's right, but 5.30 explains that those are just examples of people who don't have a genuine interest in the case. That's the principle that we say is being applied.
Okay, so Rule 78 doesn't say it.
No, but before we get to that point, so that's a challenge to me. We want to find out why. There was a consultation on that as well, my lord, on the rules, which was implementing this policy. And if we go on to tab 19,
Yep.
Okay, page 148, I'm told,
yep.
In your bundle. 554 in mine. Okay, and we've got paragraph 3.1 there.
Yep.
So there's a reference here to the previous government's position that claims that should only be brought by those with a genuine interest in the case, such as representative bodies or those who have themselves suffered loss. Paragraph 3.2 refers to the proposal in the consultation that preceded this document that there should be a presumption against lawyers, SPVs, and funders bringing claims. And then over the page, we've got the government's response. And at paragraph 3.5, the government decided not to introduce that presumption. But the reason why is important. That was because what was needed was flexibility. And the government referred to the possibility that an SPV might be established to genuinely represent the class. So the government did not want to rule out the form in which someone with a genuine interest in the class could bring their claim if they wanted to do that through.
No, that's an SPV who they said otherwise wouldn't have a genuine interest. But here they're saying an SPV might have a genuine interest because it genuinely represents. So the test they then apply in 3.4 is only those who fairly and adequately act.
That's right. That was the test that was being put forward, and that's what we find in the rules. But paragraph 3.7 makes clear that the government's policy intention on this issue has been made very clear. And we say that that's right. We've seen that in the documents that we've just seen.
The test has become fair and adequate.
Oh, I'm sorry, that's a subtlety that I...
So 3.4, only those who would fairly and adequately act.
Yes.
And then 3.7, the guide will set out the criteria
That's
that will consider when determining whether a potential class representative would fairly and adequately act.
Yes.
So it may be someone who's not in the class, but will fairly and adequately act in the interests of the class.
That's right. And we don't say that he has to be a class member. So, for example, in some other cases, what you see is someone is an academic with an interest in the field. Or in one case, there is a trade association in trucks, which I think your lordship's that on.
Yep.
There's the RHA. So those are all examples of bodies that have a genuine interest in the claim for other reasons. But we do say that it is a relevant consideration.
Okay, what do you mean fairly and adequately? I mean, this is all from the perspective of the interests of class members. I mean, by definition, if somebody's acting adequately in the interests of class members, he's acting contrary to your interests. I mean, it's a bit of a mystery to me why or how defendants are so vigorous in complaining about the people who are suing them on behalf of the class. I mean, it's a strange world that we...
Some are more effective than others.
Well, my lord, no, that's not it. Our concern is really the concern that's been identified in the consultations, which is that otherwise the system ends up being open to abuse. It becomes open to claims being put together to get over a hurdle, which can then create money that can flow through to funders. But you end up facing allegations from people who just know nothing about the material they're signing statements of truth about. And that has actually happened in this case. So Mr. Gutmann simply made allegations, not just the ones that you've been seeing, but also allegations about the later devices, the iPhone 8 and the iPhone 10. He made the same allegations about them, even though there was never, it's now accepted, never any factual basis for those allegations to be made. Now, those have now been removed from the case, but only after Apple spent considerable time and money and time of its engineers as well, time of its senior people like Mr. Crumlin, trying to answer these points. And a world in which someone who's got nothing to do with it...
If you made those submissions to the CAT and the CAT said, okay, well, we hear those, but nonetheless...
Yes.
That's a judgment for the CAT. Why
absolutely.
Where did they go wrong in law?
No, absolutely, my lord. So we do need to look at what is said about this in the judgment, which is back in the core bundle. My submission is that the CAT didn't answer the point that I'm now putting to you. To be fair to the tribunal, it wasn't developed orally, but it was all set out in writing, including those references to the consultations. In fact, I think full quotes from those paragraphs. But it's paragraph 64 of the judgment, page 63. And what's said in paragraph 64, they refer to our point that Mr. Gutmann is not a class member, and the only response there is that, well, there's no requirement that he should be. But we don't say there's a requirement that he should be. Then paragraph 65, there's a reference to our point that Mr. Gutmann had abandoned parts of his claim. And again, what the tribunal says is, well, there's nothing wrong with abandoning parts of your claim. And of course, again, that's not the point we were making. Then at paragraph 66, he refers to our point that he wasn't the tribunal refers to our point that he was a professional litigant. And all the tribunal says about that is that it wasn't pressed at the hearing. But it wasn't abandoned either, my lords. Lord Wolfson, who was addressing the tribunal on this, on everything, accepted that he was not likely to win in the tribunal on authorization if we lost on everything else. And so said he was going to focus his oral submissions on the other matters. But he did not abandon our submissions, and he expressly referred the tribunal to our written submissions, which developed the point in full. So we say here that the error of law here is that there's nothing that grapples with the point of principle that we've raised at all. There's no discussion of the consultation materials. The tribunal does not deal with what we say about why, in this type of case, which is about the experience of class members, which is an unusual feature of this case, it is particularly important that the class member who has someone who has a genuine interest in it, has got some connection to it, so that you can trust them to run the case in a way that's fair not just to class members, but it's fair to a defendant facing him as an opponent, Because if we were facing individual claims, we would be facing claims by people who had the iPhones in their pockets, who said that this was an experience that they had had, and we could test that. But we do say it's really unfair for a defendant to have to face these kind of allegations and have them being, as I say, plastered all over the place from someone who's got nothing
So
to do.
again, what's your complaint? Is it irrational conclusion, or is it failure to give reasons, or what?
We say that there's just no answer of any kind given to our point. So it's a failure to
The
take
point
into
is
account.
that the essence of your point is that he doesn't have an interest,
An interest in the relevant sense. Yes, that's right.
even though that's not in Rule 78, and it doesn't seem to be in the government's response of September 2015.
Well, the government's response of 2015, as I showed you before, said that their policy intention had been made clear and was not changed.
But they say at the end of 64, I mean, first, in 64 they say, doesn't have to be a member. We've looked at the merits. We don't find this an unfair case. It's not improper. It's not an unfair or improper use of collective proceedings on the merits. We've looked at what he's alleged and has abandoned. Okay, well, that's not out of the ordinary. And he's a professional litigant. But
although there's no...
So what?
I think your real problem is in the analysis of SPVs. Originally, SPVs were out because they didn't have an interest. Then they said that goes too far. They may have no interest whatsoever, but they may be able to be there because they fairly and adequately represent. So the absence of interest disappeared.
No, my lord, I think what that was referring to is a situation where someone or a group of people who do have an interest in the claim
I'm not certain that's...
create an SPV in order to represent it. I think that's what's being said that's my submission in any event, what's being said in the consultation.
We understand.
And as for the rules, we say those rules, as the government said in that response, those rules are cast very widely, so that this submission fits within its rubric. Not in every case, I don't need to go that far, but in a case like this, that is about the experience of class members, we do press that upon the court. So, my lord, there is a point that's been raised about jurisdiction in relation to this this ground. I don't know whether your lordship wants me to address you on that, but
Briefly.
Yes. So what is said is that this is not the decision to authorise Mr. Gutmann is not a decision as to damages, and therefore does not fit within this court's jurisdiction under Section 49(1)(a) of the Competition Act. And that submission was based on this court's decision in Packard, which found that a challenge to the PCR in that case, based on a technical problem with the funding agreements, was not a decision as to damages. Our answer to that point is that the law has moved on since this court's decision in Packard, and subsequent cases have explained that almost any decision of the tribunal will be a decision as to damages.
I don't think we went pretty close to it, but not far off.
Almost. I was going to show you exactly what's been said, my lord. And
in ethics, I think we said Packard needed to be confined to its own facts.
That's right. And what those facts were was that there had been a finding by the tribunal that even if the funding agreement was unlawful, it could be cured without making any difference to the case, which would then continue. So the most recent authority on this is this court's decision in McLaren, and we have that in the authorities bundle at tab 10. Feeling nervous about the page references at this point, but I'll give you the paragraph reference. So I've got it at page 349, and it's paragraph 38.
Sorry, paragraph 38.
That's right. And it's McLaren 2024, not McLaren. Not McLaren.
Oh, right. Yes. Okay. It's Protestant Popper was.
That's right.
Yes.
Sorry.
So it's the one that's 2024 Business Law Report. Should be around.
This is the case where they convene themselves as a court of appeal at the last moment.
That's right. Yes. In fact, after the hearing, they made the decision on what we had been.
I remember it well.
Yes, I'm sure, my lord.
There's a certain amount of internal discussion as to how to deal with the case.
I'm not surprised to hear that. So I was just going to invite you to read, really, paragraph 38 and 1 to 6 to yourself.
So if we're going to duff you up, you'd rather not be done on jurisdiction?
Oh, my lord, I just think it's right that I should address you on.
Okay, we understand. Yeah. So it's, yeah.
Yeah, so the other point I want, so we say that this point does fare squarely within what is now said about the jurisdictional test. Because if Mr. Gutmann is not authorised, well, nobody knows what will happen at that point. It may be that anyone who does have a genuine interest in the facts of this case would say that this claim is hopeless and I'm not going to pursue it. In that case, that would be a good thing, we say, because the hopeless claim is not being pursued. So that's why this may well turn out to be an end-of-the-road scenario. The only other point I just want to make about that, about jurisdiction, is that I mentioned at the start there are those funding appeals, and not just in this case, but also...
There's 3 of them, I think, in total.
That's right, my lord, yes. And those are actually raising the Packard point.
Okay, but so what?
And those are all, including, we've got permission, those are all being treated as...
What's that got to do with the identity of...
That's where the point goes. The way it fits into the rubric is that if the PCR has a funding agreement that is unlawful or has the other problems that we have identified in our funding appeal, then that's relevant to the decision.
Well, how? I mean, the legality or otherwise of these funding agreements has baffled and bemused people at all levels of the court system, without any suggestion that it makes them improper or otherwise to... Yeah, I mean, I think your skeleton goes as far as to say it's just inappropriate or improper that somebody should have signed up to such a document.
That's for a different reason, my lord. So that's not the Packard point. That's one of our other grounds of appeal on funding, where what we're saying is that Mr. Gutmann has undertaken obligations in his funding agreement to act contrary to the interests of the class. I can't now remember which bits of that are confidential and which bits aren't, but I don't want to say too much more about that. But that is a submission that goes to him as a PCR, whether it's appropriate or. But I accept, my lord, that they're different. That those points are different in character to ground 4 that we're impressing upon you today. It's not the position that one of them follows from the other or anything like that. All I was saying is that it's interesting that now all of those types of cases, which in Packard itself were treated as judicial reviews, are now, in light of the subsequent authorities, being treated as appeals. We say rightly in light of what your lordship said in Forex and what Lord Justice Popplewell said in McLaren. Oh, I'm so sorry. The transcriber has asked for a break, but I was about to finish. Unless your lordship's had any further questions for me.
5 minutes. Come back at 22.
What round is it? The only point we've made. Yeah.
You can hear.
Court rise able.
My lords, I wonder whether I can start where my learned friend finished and deal as briefly as I can with his ground 4, which is the suitability of the class representative. This is a point on which, as my learned friend indicated, the CAT in fact heard no oral submissions. My learned friend Lord Wolfson KC, in my respectful submission wisely, decided not to address the CAT orally on these points and directed them to his skeleton argument. They are truly unarguable.
Sorry, just do we want submission? You can take this very briefly.
Yeah, very briefly indeed. If you're going to deal with it in your judgment, the first point is it's not just about the guide and the rules. There is also the statute, which I think we haven't seen yet, section 47B8. It's behind tab 13 of the authorities bundle, internal page 59. The tribunal may authorize a person to act as a representative, A, whether or not that person is a person falling within the class of persons described, B, if it considers it's just and reasonable for that person to act as a representative in those proceedings. Mr. Gutmann is, of course, a recognized consumer champion. He, after years at Citizens Advice, has been certified in other cases. Only last week, he successfully obtained a settlement in one of the railway cases against Stagecoach with a sum of up to £25 million to be made available to consumers. Not only can he act fairly and adequately.
That was a boundary case. It was
Boundary affairs case, yes, one of the boundary affairs cases. The others proceed. So he not only acts fairly and adequately, he also acts very successfully. That is perhaps why defendants like Apple don't want Mr. Gutmann on the other side. I'm going to leave it there. I hope that's appropriately brief enough. On grounds 1, 2, and to some extent 3, just to remind ourselves, ground 3 is the point about the temporal limit. My learned friend, in his submissions, one might be forgiven, who didn't know about the case, thinking that he was saying that the apology and the information was always out there at all material times. No, ground 3 is about whether it's beyond December 2017 only. My learned friend said he told a story. He did tell a story. Like all good stories, the storyteller tells the bits that will drive his narrative. I'm not making any suggestions of impropriety, but it is important, not least to understand what appears to be baffling my learned friend or the court, this intertwined nature of the substandard allegation and the rest of the allegations. I will briefly tell the story from our point of view. So we came...
Well, just before you tell
Yes.
the story, do you say there is a standard, if so which, below which these iPhones fell, and if so, in what respect? I mean, or is it just a linguistic flourish to say they are substandard?
Without wishing to duck the question, it is probably a linguistic flourish to say that there is a specific standard in the sense of a warranty or a consumer law legal claim. What we do say...
So just unpicking that sentence, it is no part of your case that these phones failed to meet a legal standard, so as giving rise to a warranty or other claim. Because if it isn't, I mean, it's unfortunate that the word substandard has been used in what is a legal document. It is, I mean, it's not a work, it's not a literary work. It's supposed to be a legal document. If you're saying, no, substandard doesn't have a legal meaning, well, can we...
But it has a technical meaning. That's where I'm going to come to. What we haven't heard at all from my learned friend is the fact that there was extensive technical expert evidence before the tribunal. And my case before the tribunal was that if you look at the technical expert evidence that we have now, and as we hope it's going to be at trial, there will be a premium standard for telephones of this kind, for which a great deal of money is charged to consumers.
So a premium standard?
A premium standard. They're premium telephones.
So what is the standard? Who sets it?
Well, the standard will be in the evidence, because what we had, and you haven't got before you anything approaching the fullness of the evidence, but what we had is we had an expert report which equated CPU, so processor performance, with consumer experience. And as soon as the processor performance dropped below a certain level, the user experience was such that it is our case that it was below the standard expected of a premium phone. And that was not a case that has been found to be hopeless.
By whom?
By the consumers. The consumer experience will be such that it will no longer be the premium iPhone that they expected to buy, and therefore it is worth...
reduced technical performance?
Reduced technical performance in the sense of the CPU, the processor unit, running so slow that it no longer adequately performs.
Because your pleadings talks about, in very wordy language, reduced technical functionality and substandard performance for the same premium price. In fact, inferior handset quality as well, reduced technical functionality and substandard performance. Can we just unpack what you're actually trying? I do have a real problem with your pleading, a real problem.
And so did the tribunal.
The complexity and the imprecision in the use of words. And if it goes on, this case is going to fail to be focused. And I think that's what may lie right at the heart of trying to pin you down as to what this case is actually all about.
But I mean, to be fair, to some extent, that's what the tribunal has said. And the Court of Appeal is seeing the case freeze frame at a moment between the provisional certification and the disclosure and repleading, where the tribunal has made exactly the points you make, and we haven't resolved from.
But what's going to come out on disclosure that's going to be relevant to the question about whether you're running a technical case or not?
Well, we are running a technical case,
but there's nothing to support it, the tribunal has said.
No, the tribunal has, with respect, the tribunal hasn't said that. My learned friend says that's what the tribunal has said. But if I take you to the judgment, that part is still open. And it's quite specifically the part in which I addressed the tribunal, which related, we produced a table, it's not in the bundle, we produced a table from the disclosure that we got, which showed the CPU performance. And I said, if you want to draw a line as to where the standard is, draw it a third up that table, which shows where CPU performance dropped off into an area that was substandard. You won't find it in the judgment, but I will seek to explain to you where in the judgment that is being addressed, because that's what must be being addressed.
Is this the difference between the two parts of paragraph 41?
It is, but also the earlier part of the judgment in paragraph 35, to which it necessarily refers. Can I just take a step back, because we've leapt into this. I understand why, but in order to understand where we're coming from, I'm sorry, did I say 35? Yes. To understand where I'm coming from, can I just take a step back to where we were at the outset of this case? Because partly, all of this information has had to be drawn out of Apple in disclosure, even though you're now being presented by Apple with a story as though this was always known. But when we first came to the tribunal, there were two hearings, one in spring and one in the autumn. When we first came in the spring, we had what we considered to be compelling circumstantial evidence of the sort of issues that we were complaining about. In particular, there were the proceedings in the United States that have been referred to, and the fact that there was a multi-hundred-million-dollar settlement there, albeit without admission of liability, but clearly Apple reacting to the very same complaints in the United States in a consumer action with an enormous settlement. Furthermore, we had evidence from user groups online detailing the extent to which they'd experienced a slowdown in phones, and we knew that there had been no official reaction of the kind that Apple now rely on at the relevant time this was all happening. We came before the tribunal with that, and the tribunal, exercising its gatekeeper role, said to us, we don't think this is good enough. You haven't got any primary facts. We're going to order some disclosure. And we got a number of items of disclosure, three important items I'm going to mention because they're reflected in the judgment. We got a set of tables, and they are euphemistically described as...
These are the mitigation tables?
Yeah, they're described as mitigation tables. Actually, the internal name for them, it turned out, was throttling tables. And as a side remark, if I may, that was quite interesting. It illustrates how this litigation has unfolded. Because at the beginning, we were told that throttling was a terrible term that we ought not to use. That argument fell away once it became clear that they had been using it internally. The phones had been throttled by way of the PMF, and the throttling tables, mitigation tables, indicated the extent to which this had taken place. So there's no dispute between us that the PMF slowed down the phones. It's just a question of the impact that had on consumers, which is going to be a matter for trial. So one thing we got were these mitigation tables, which we submitted, told a compelling story about the slowdown and the subsequent loss of the premium nature of the performance. We then had the CMA letter, possibly the single most important piece of disclosure. We also got a certain amount of internal emails and communications from Apple, including discussing the extent to which it now took longer for the phones to perform, depending on the level of mitigation stroke throttling. When we came back before the tribunal, in the hearing that led to the judgment that they're seeking to appeal, the tribunal still wasn't persuaded by our circumstantial evidence. So if we look at page 51 of the core bundle, the analysis of the evidence that we were presenting, at 30, they doubted that what we relied on in relation to the advertisements, the blazing fast performance, and so on, can be considered sufficient. At 31, they dismissed the argument about 70% and 90%. And at 33, at least at this stage of the proceedings, they weren't persuaded that there was a potential legal claim for compensation.
When they say legal claim for compensation, are they talking about contractual warranties, or what are they talking about there?
Contractual warranty or consumer law claim.
So they're not talking about abuse, they're talking about consumer law.
They are.
Yeah.
This is essentially about causation. What have the consumers been deprived of? Because
Yes.
it'll be too late to bring these claims.
Yes.
So, and it is true that that's in the context of, because the affected iPhones were, quote, substandard, which is essentially a shorthand, or fell short of particular representation.
Yeah.
But that is not, at least as we put it, the end of the case on the standard or performance. What then happens is there's the reference to our argument about consumer pressure, and the argument of consumer pressure has always been a straightforward one. Look what happened in the United States. Look what they did by way of partial redress for cheaper batteries, even in a case where they said there was no case to answer. If this had all come out at the relevant time, we say there would have been consumer pressure. The CAT accepted that. At 35, then, there's the reference to the first bit of disclosure that was to some extent accepted as being probative. And that is the mitigation tables. So disclosure has been provided by Apple, which gives some further insight. Mitigation tables have been disclosed, which detail the circumstances.
Sorry,
yes.
I need to try and get my head around this. Are you or are you not running a case that there was a breach of warranty or a breach of consumer law?
We are running a case that one of the aspects of the abuse is that the consumers were deprived of even testing whether there was a breach of warranty or consumer law. Because of the lack of transparency. The fact that this was kept from them meant that they couldn't at that time avail themselves of legal warranty or consumer law. For my case, I don't have to show that they would have succeeded in any of that. It would have been part of the consumer pressure that would have led to Apple reacting and either reimbursing them or providing a
loss of a chance. Loss of a chance.
Yes.
And what's the problem with warranties? Is it that these couldn't, on any view, fall within the scope of the warranty, or that they're time barred?
They're certainly time barred.
Well, that would go to loss of a chance.
Yes. That was the issue we had with both of any warranty claims and consumer law claims. It's fair to say that this wasn't explored in detail because it's not in fact central to our case. It's part of the background of the abuse. And I don't want to breach confidentiality, but it's not dissimilar to what's there in the CMA material. And as your lordship said, at this stage, who are we, who's the cat, to go behind the view that the CMA took? Consumers were put in a position where they made different transactional choices than they would have made if things had been transparent. And it's intertwined with the performance of the phones. And that's the point I'm trying to make about paragraph 35. Because they don't say, this is a hopeless point. This is the point where I made the argument about if you look for a standard, look at the mitigation tables and draw a line where they start to fail. And the tribunal says over the page at 53, it is difficult, I say brackets, not hopeless or impossible. It is difficult, however, from the tables alone to know what this means in terms of user experience across the proposed class and whether this is arguably sufficient to lead to consumer dissatisfaction. So they've got the point that I'm making, which is there would have been consumer dissatisfaction. They would have complained, they would have tried a warranty claim, they would have tried a consumer law claim. There would have been an action and a reaction. And they haven't said, this is hopeless. On my mitigation table's argument, one of the three that arose out of the disclosure, there is essentially an open verdict being returned by the tribunal. Difficult to say at the moment. Then we move on to the second area of disclosure, which was the internal emails and so on. Effects of throttling were noticeable. Now, internally, it said they were deemed livable. The tribunal says it deemed livable is consistent with this potentially being of concern to consumers, but not of such concern consumers would not put up with it. But then there are some other figures mentioned, saying that certain apps would take 3.5 times longer. Not possible to conclude one way or another without hearing evidence whether up to 3.5 times longer will negatively impact the performance of the product from the perspective of consumers to leave them dissatisfied.
This is Safari.
This is Safari, for instance, yes.
Yeah.
So here is the second area of disclosure that we did get, and that has led to a triable issue. It's not, in my submission, certainly for the Court of Appeal to go behind the CAT's assessment on that. The third important area of disclosure was the CMA letter. And that's then referred to at paragraph 40. And that is perhaps the item of evidence that most persuaded the CAT in relation to triability and certification. It is being treated as confidential, really for reasons of the class representative not wanting to pick every fight with Apple. So we said, all right, if you want to have it in a confidential annex, put it there. But you will see, and I'm limited therefore in the submissions I can make, you will see what is said about it at pages 66 and 67. I have, by the way, brought, if it assists, copies of the Consumer Protection Regulations 2008, which are referenced in the letter.
We've got them. We've printed them off.
I'm grateful. That makes it perfectly clear what they were concerned about. And Regulation 5, Regulation 6...
Well, for both Regulations 5 and 6, there has to be a finding of causation.
Yes.
For either the omission or the commission.
Yes.
And it has to causally lead to a difference in conduct.
Yes.
Transactionally.
Yes.
And those are the minimum legal requirements of both Regulations 5 and 6. Yes. That's the context of the CMA letter. So we have the CMA referring to it in paragraphs 40, 42 and 43 and saying there may be further disclosure coming out of those proceedings. But the legal requirement for even a provisional view is that there has to be causality between the commission and omission, misleading or omission, and a difference in conduct on the part of the consumer.
Which is exactly our case. And the CMA came to that view, having seen all of the documents, and the CAT can't be said to have acted irrationally, having looked at that, and said, well, if that's the conclusion they came to, at least prima facie, there's a case here. Let's have some disclosure. And your Lordship picked up with my learned friend the question of disclosure, and he quite fairly said, yes, the way that the CMA disclosure worked was on the wording that they had suggested. We did, in fact, pick up on...
There was no information in response to RFIs?
Well, no information in relation to documents that they'd created for the CMA.
Yeah.
And we did pick up on the fact that they'd chosen that wording, and then afterwards it appeared from what we saw in the footnotes. That meant that there were certain things we couldn't see.
The CMA's letter refers to information generated for the purpose of the proceedings upon which it then relies.
Yes, exactly. And that had been bracketed out by Apple from the order that was made. And they knew, of course, what the CMA letter said at that time. We didn't. They had an opportunity to give more disclosure. There was a hearing in August where we came back and said, can we see more? The CAT said, no, you're not going to see more. The defendants gave us a little more on some aspects, but they didn't give us more on the CMA materials. And that's on them. That's not on us. And they say, well, there would have been something. They've said consistently, there would have been something in these documents. That's not the view that the CAT has taken. The CAT, you've pointed out correctly, Your Lordship has pointed out, the CAT has found that more documents are to be expected. And that's not that surprising. For instance, there were upwards of 300,000 documents disclosed in the United States proceedings. How many did we get? We got 30. So the suggestion that somehow we will have seen anything that really matters is to be taken at the very least with a pinch of salt.
Okay, that's fair. We understand. We've got to be relatively efficient in the way we conduct the proceeding. Can you help with paragraph 41 of the judgment?
Yes.
Which is where the CAT draws the line between that which it's going to allow to be run and that which it doesn't. And the first part is, it says it's not convinced about this, but this is this does link it into breach of warranty or statutory rights. But then in 42 and 43, they go on to say, well, we're not going to strike that out. Now, that does then bear upon what you say about the possibility of advancing a claim which may generate pressure, regardless of whether ultimately a claim for example, breach of warranty would stick. But here they seem to think, no, but they're not going to strike it out. Yet that's, at least on one view, not entirely the way the CMA saw it, because they were clear that both warranties and statutory rights could have been part of the causal consequence of the provisional finding of breach.
Yes, exactly so. It is puzzling, and perhaps the liberating thought for the CAT was that they allowed it all anyway because they said it was intertwined, which is right with respect, and they say that at paragraph 43. But the way that
you're going to have to help me with the word intertwined. They say the question of whether the affected iPhones fall short of a legally relevant standard. Now, just pausing there, they have previously recorded that you had not put forward any findings of any primary facts which gave any reason to believe that you would be able to successfully maintain a claim that the phones were substandard or gave rise to a particular legal claim. And you are recorded at 34 of having made clear that your case was not dependent upon members having an entitlement in law to compensation. And I'm struggling to understand why, given that you seem to be ruling out or not wishing to put forward a claim that the phones didn't meet legal standards, that could be intertwined with an allegation that the performance of the phones was materially impacted. I mean, I understand an allegation that the performance of the phones was affected by the PMF, and that might have had consequences. What I don't understand is why an allegation of falling short of a legally relevant standard is intertwined with that at the moment.
It's intertwined in the sense that the evidence that leads to the conclusion as to whether or not it was short of a legal standard is the same evidence as that leads to the technical performance, the mitigation table evidence. And so there is, in truth, nothing.
We understand that you're going to have evidence to show that the introduction of the PMF led to a reduction in performance. Then you say that had various consequences. That, I understand, is in essence the alternative case which is set out here. What I think the objection under ground one is that you've set yourself up, it would at least appear on the pleadings, to another case, a different case, which is there is some legally recognised standard, i.e. one which gives rise to a claim for breach of warranty or some contravention of consumer rights, and that was infringed. And my understanding is that Apple is saying, look, the tribunal have said that that case about infringement of warranty or consumer rights is one for which there is no support. The tribunal said there was no support, and they haven't in fact pointed to any potential disclosure that would go to that point that could be expected in the future. So what's it continuing to do on the pleadings?
Well, I mean, as we continue the discussion, it's fair to point out that we are, especially in the way that my learned friend has put what he actually wants to strike out, talking about a much narrower argument than I expected we would have to meet under ground one. I thought any arguable substandard technical nature of the phone was being struck out. As I said below, I don't have to show that they would have won a warranty claim or a consumer rights claim, and that's not part of my argument. What I say is that they would have brought such claims, whatever the outcome of those claims would have been, and it would have led to the counterfactual that for which we contend, which is that Apple would have had to react. This would have been part of consumer pressure.
So are the words that were objected to, for example, in paragraph 158 of your pleading, words that you need? Because they clearly suggest, or at least on the face of it, suggest that there were legal rights under the warranty or through separate complaints, whatever that means, which people were impeded or deterred from exercising. And if you're not saying that's what your case is, well, can we not? Why shouldn't the cat have struck them out?
In fact, what we're saying, we do need most of those words, but in fact what we're saying on this, which is almost a micro point with respect, but on this we're saying impeded or deterred from attempting to exercise any legal rights, whether under Apple's warranty or through separate complaints to seek a refund, etc. See the letter, because that is all part of our causation argument. So, as below, I'm not saying, because I don't have to say, oh, well, they would have won this warranty case, they would have won that consumer law case. What we're saying is there would have been the general upheaval that we describe, which would have led to the outcome for which we contend. And striking all of it out is therefore throwing out the baby with the bathwater. But yes, absolutely, it can still be improved. And that's also something we haven't shrunk from, because the cat has identified this and said, oh, you're going to have to get this in order. And we have said we will put it in order. We are at a stage.
Well, you've been asked to do it at the moment by the cat after disclosure.
Yes.
But disclosure is normally done by reference to the pleaded allegations. It's putting the cart before the horse, isn't it, arguably?
Yeah, but there won't be any disclosure that would be different as to whether we say exercising or seeking to exercise. That this is a pure legal argument. Nothing about the underlying facts which relate to the performance of the phones, and essentially a technical argument vis the mitigation tables, vis paragraph 35 of the judgment. Nothing about that disclosure is going to change whether this wording is in or out. So this is an argument about very little, as I now understand it. I thought my learned friend was going to come and say we're not allowed to make any sort of allegation, legal or technical, as to the phones not performing to a premium standard. That, of course, is part of a core part of our case.
Well, it depends on what you mean by premium standard.
Of course, but that's ultimately going to be a matter for technical expertise. We have an expert.
You're not talking about a legal standard. Premium standard is not a term of art.
No,
It is just simply a description of how a product might be perceived in a marketplace and whether or not, by the conduct alleged to be abusive, it has fallen below that to such a degree that it stimulates a reaction to which an undertaking in a dominant position either has to respond or would de facto respond.
Exactly, my lord. And that's the discussion we had in the CAT.
So the expression, therefore, premium standard, it's not only not a term of art, but it's just a sort of advocate's flourish.
I'm happy to stand guilty of that. But one has to say something.
When you do it on a pleading to create the sort of confusion that it seems to have caused, aren't the count arguably wrong not to sort of take a blue pencil to the pleadings and strike out those bits which don't appear to have any legal consequence?
Another tribunal might have done it differently and said, this is what we want struck out, that's what we want to strike out. This tribunal took the case management decision that they're going to let this case proceed, and then they're going to ask the class representative to put his pleading in order, and then it'll see. And as they say in paragraph 73 and elsewhere in the judgment, that's when they look at it in the critical way that my learned friend wants the Court of Appeal to second guess the CAT, the Specialist Tribunal. That's when they look at it in that critical way and say, all right, well, this is in, this is out. And we've seen a perfect example in, you've pulled me up rightly on what I say in paragraph 158, which is no longer accurate in the sense that I described, but you can't strike out all of that which my learned friend wishes to strike out, because it removes a building block that remains intertwined with our whole argument around causality.
But you say it wouldn't prevent you putting back in something which was a more nuanced and different version, but you weren't you didn't have a legal right which was proven. There wasn't an automatic right to exercise it, but you had a right to make an attempt to see whether or not you could exercise a right, and whether right or wrong that would give rise to pressure.
Absolutely. And if one looks at the opinion of the CMA, it seems that was something that would have been well within the contemplation of the reasonable consumer or his representative. But not being told a couple of years later when it's too late to do so. So that's why that is intertwined. And I fully recognize and say mea culpa. The current...
I'm just interested, I mean, the paragraph which they haven't cited in the judgment is paragraph 32 of the CMA letter, which talks in terms of, in line 6, seeking an alternative remedy.
Yes.
Yeah.
So I can see where the confusion arises, and it arises from the pleading, and I apologize for that. But as far as our submissions are concerned, I hope I was clear in the CAT, and I hope I've been clear today, as to how we rely on the warranty and consumer claim arguments. And it's not to say we have to prove that they would have won them, or that a specific legal standard was not met within the meaning of any specific warranty or within the meaning of any specific consumer law claim, although obviously it is possible that it was. But that's not going to be decisive, because this isn't a consumer law claim, this is about the abuse. So that's where I see grounds 1 and 2 in. I noticed the time, by the way, but
yes,
if you're happy to proceed, I can try and probably wrap this up in the next 12 to 15 minutes.
Just okay, I mean, we think we understand the difference between the parties and your point on grounds 1 and 2. We would like you to address grounds 3. We understand the parameters of the debate on ground 4. So yes. If you could just address that, then we'll give us the pitch in, unless there's anything final you wish to say.
I'm grateful. So ground 3 is about the cut-off date. in
Yes.
the judgment, if we're still in the judgment in the core bundle, it's addressed at page 56 and at paragraphs 45 and 40 to 48 in particular. Again, the tribunal has given this suitably short shrift. The allegations that are made against me and against the tribunal in that sense are that all of this information was put out there on the 28th of December 2017, and there's been no criticism made of the way in which it might be defective. Dealing as quickly as I can, because I don't need to be long, with the second of those points, in what ways is it defective? That's actually set out in the judgment. At paragraph 46, the tribunal recites our skeleton argument and sets out the 5 ways in which it was said to be, information was said to be defective. There was no mention, above all, that components were throttled and capped. There was no mention of a proper and comprehensive explanation of the significance of the reductions in performance that we saw once we saw the mitigation tables. There was no explanation of the trade-off between battery performance and other hardware components. So nothing in this, for the purposes of an appeal and rationality, nothing in the idea that no criticism was made of the content of the message. What then of the effect of the message? Listening to my learned friend, one might think that this was somehow broadcast in the widest possible way. We will see in our claim form, back in the supplementary bundle, how this was in fact broadcast on the 28th of December 2017. Supplementary bundle, page 216, is the section that starts Apple's apology. I'll take it from paragraph 100.
Yes.
On the 28th of December, Apple issued an apology. The apology was not notified to users or displayed in a prominent way, but could, one might say, could only be accessed via a link in the bottom corner of the Apple homepage, titled A Message About iPhone Batteries and Performance. And then we see what it says. It's quite long. It's in largely glowing corporate speak on what Apple has done in relation to the iPhones. The simple point is that if you really wanted your consumers to know, you would send a message to the iPhones. That's a functionality they have. You might send emails to users. Apple has everybody's email. They didn't do any of that. They published it on the corner of their homepage, which if you looked at it on the phones, you couldn't even see. It's the electronic equivalent of a company publishing an apology by posting it on its internal notice board. And my learned friend says, oh, it was picked up by the press. And one may speculate whether or not they were hoping it would be noticed by the press. The tribunal saw those limited number of press mentions, plainly didn't give them the weight that Apple wanted the tribunal to give them. And they found at 48 they were not in a position to rule. There's no reasonable prospect of the PCR succeeding on showing there was abuse after the 28th of December 2017. But the nature of the abuse is the lack of transparency in the Gutmann Court of Appeal paragraph 101 sense, which is a lack of transparency can render unlawful that which might otherwise be lawful. And the apology was both, well, obviously too late. The learned friend used the word belatedly. But also, when it came, it was inadequate in 2 crucial ways. 1, it was published obscurely. And 2, didn't in fact openly and readily explain the real problem that we only drew out once the tribunal granted us some limited disclosure in this case, and we saw what the internal discussions have been around these issues. So, Again, very simple issue. A point that the tribunal reached irrationally or unreasonably? No. And I can really draw together all of grounds 1, 2, and 3 in this way. There are two obvious ways, two obvious reasons why this court ought not to interfere with the specialist tribunal's handling of the case below. The first is that this is all a rehash of what was said about the facts and what the tribunal tried to do about that in a way that cannot reasonably be said to be irrational or such that no reasonable tribunal could have reached it. Remember, this is a tribunal that wasn't willing to have the wool pulled over its eyes. We came before it in May, or whenever it was, last year. And they said, no, we don't think it's good enough. We need some primary facts. It's the tribunal that ordered disclosure. And it's the tribunal that decided, specifically on the basis of the extra disclosure that was produced between May and September, whenever it was, that there is enough here to go further. And that cannot be said to be unreasonable. And my Lord Justice Snowden is right to pull up those on this side, saying, well, what about this argument around a legal standard, a warranty claim? I hope I've explained that. But it does lead directly to the second reason why this court ought not to interfere. Because precisely because of the way that that case developed in relation to the two hearings and as described by the tribunal in the judgment, which we are not appealing, so we're accepting everything it says and it says we need to do. Precisely because of that, there is going to be an opportunity for repleading, to make the case fit the findings of the tribunal. And actually, nothing here today has been identified that's going to put Apple somehow to any disclosure that it wouldn't have to give anyway, even if they succeeded on their ground one. So one wonders even, this is a third point, as I listen to it today, what the utility is of this. So not irrational, don't interfere with case management, and ask yourself, what's the point? And there isn't one. Thank you.
Do you have any view on the confidentiality debate that we had with Mr. Bitunen at the beginning?
We've always said that we're going along with Apple for the sake of peace between the parties, with the idea that they want to treat this confidentially. We have also always taken the view that eventually this will have to come out of confidentiality as this goes further, and we don't resign from that view.
So that's not really an answer to the concerns that we were expressing about requirements of open justice and the tension between that and a particular party's desire for confidentiality. Well, and so that's really what I'm interested in you, whether you've got anything to say on that subject. Just to say, well, we've always gone along with Apple because, you know, they're our opponents in this litigation doesn't really address the question.
I'm torn between what the court needs and what the parties, how the parties have proceeded for once a rather cooperative way in this case on confidentiality. I absolutely hear the points in relation to open justice. It is extremely hard to understand what is probably the principal reason for the CAT's decision without understanding what's in the confidential annex. And as such, from an open justice perspective, that is suboptimal, to say the least. We have never opposed this material being made public. We have simply agreed with Apple's position that they wanted it in a confidentiality ring. And so that's probably all I can say.
Thank you very much.
Lords, I can be very brief in reply. I just want to address my submissions in reply under 3 headings corresponding to the first 3 grounds of appeal. I think you have my submissions on the 4th. in relation to the first ground of appeal concerning the allegation of substandard performance, I'm afraid to say that on our side, we find the developments that we've just heard astonishing, given where we are now. This issue of what the PCR's case is, as to whether there is an allegation that the devices were sub any particular standard, what that standard might be, why it was said that they were sub that standard, it's been debated at great length over 2 substantive hearings already, the 2 certification hearings already. The same questions that my Lord Justice Snowden put to my learned friend were put repeatedly by the Competition Appeals Tribunal at both of those hearings. That led to the debate that is then reflected in the judgment. Paragraph 28 of the judgment, which is on page 51, identifies, the core bundle, identifies the answer that was given by my learned friend at those hearings. There was no suggestion in response to this judgment that it was a mischaracterization, an obvious error, if you will, a mischaracterization of what had been said at the tribunal. Therefore, in response to this judgment, we have applied for permission to appeal on the basis that this is the target we're shooting at. And then my learned friend stands up and says in this forum, oh, that wasn't my case at all, and proposes to make amendments to his pleadings on his feet. And we say, even then, my lords, there is still no coherent account now as to what the standard is, why the relevant devices fell beneath that standard, and what evidence was going to be deployed at trial to prove their case. The clearest thing that was said is that what they would like to be able to say is that consumers could have sought to argue that the phones were in breach of warranty. And so, in other words, that it was arguable that they were substandard. But even if that is the case that is going to be articulated, it needs to be said, well, what would those consumers be saying? What standard would it be alleged that those devices fell under? What is the warranty that those consumers would have alleged had been breached? We're still none the wiser as to what this case is that we're supposed to be meeting. So that's the point about the lack of clarity in my learned friend's case, and we do endorse what your Lordship put to him in argument, which is that it should be struck from the case.
But why do you say it's legally wrong, such that the Court of Appeal ought to interfere, for the CAT to say, for example, well, we sort of understand that the case isn't made out at the moment, but let's let it all hang out until after disclosure on the basis that it can be tidied up and narrowed and refined then?
Yes, my lord. The answer to that is the one I gave to you before, which is just that it is unfair for my clients to be put in a position where they are continuing to meet allegations of this kind, particularly when they're shifting, actually. The fact that they continue to shift like that makes me more concerned about it, not less. We're entitled to know the case that we're going off to meet in disclosure and in defences when we plead it and all of that. And it's just unacceptable to allow a PCR to be making allegations of this kind, which are serious allegations, that have no proper factual basis. Just before I leave that topic...
We're quite troubled by that. I mean, it would have been much better if the confidentiality issue had been grappled with earlier, and we could have had a full analysis of the CAT of that decision. We just don't get it. And we're left with rather gnomic statements about the letter, but no analysis of it. That's possibly where this has become confusing, because the CAT didn't grapple with that early enough.
Well, my lord, that was my next point, actually, which was really moving on to ground 2, because that's where it comes up. And we say, actually, that the amount of analysis that there is in the decision is approximately the right amount of analysis, because there's not much more you can do. We do say that it would, under ground 2, that it would be irrational for a tribunal to rely on and just accept as establishing the defeat of a reverse summary judgment application conclusory statements from a third party, even from a third party regulator, A, at all, B, especially in a provisional decision of this kind, and C, even more so where you have actually ordered disclosure of the contemporaneous material that was provided to the CMA in relation to these issues. In those circumstances, we do say that a decision that says, I see that the CMA has expressed the following conclusion, therefore, that conclusion has a real prospect of success at trial. That is not.
They wouldn't have said that, would they? They'd have said, this is a reason for us deferring matters.
But that requires...
Which is sort of what that's what they've said, and we just don't understand what their analysis of the CMA letter is.
There's nothing to analyse, my lord. When you read it, and I can see that you now have, all you have are the statements of conclusions. There's no discussion of, the reasons why the technical performance of the devices or anything like that, any documents from Apple.
That might be a reason for ordering disclosure of what's underneath it. And they may come to the conclusion it's utter nonsense.
Well, my lord, the difficulty is that we have given them the mitigation tables.
Yeah.
So we've given them, so they know that it's important to think about what that means, my lord. They know what the technical impact of the PMF was on these devices. They had an expert who could have looked at that and said, actually, when you look at that impact, that does add up to substandard. Here's what the standard is in technical terms. Here's why it falls short of that. None of that evidence was put before the tribunal. There was a report by a technical expert, but it just didn't say that at all, my lord. And so we say in those circumstances that it is irrational just to say, if you go back to the easier principles, my lord, it's not enough to say that something might come up. You actually have to have some reason to think that it would. And unless the CMA document has footnotes referring to contemporaneous evidence that you think might support those, or some oblique reference to what it might be, then the mere conclusion can't be enough to allow the claim to go forward. The related point, my lord, it returns to the exchange that I had with my Lord Lord Justice Snowden about the purpose of the disclosure exercise. This is another point about rationality. The whole point of the disclosure exercise was that if there was going to be material that supported Milena Friend's case, then at least some such material would be produced. Instead, all of the material that was produced that bore on the case at all was inconsistent with Milena Friend's case. And in those circumstances, we do say that it is irrational to say, well, nevertheless, just because there is still more that hasn't been disclosed, we need to go on to provide that more. In relation to ground 3, this was the temporal cutoff, and I absolutely accept what my learned friend said, that this point only really bears on the period from December 2017. Although I hope it wasn't lost on your lordships what I said about the timing for iPhone 7, because iPhone 7 was December 2017. So there was a period of roughly 4 weeks between the PMF being downloaded or made available for download and those materials being produced. But subject to that, we do accept that this is a point that goes to temporal scope. It is important, though, because it then feeds into what we say about causation when you go back to ground 2. But my two objections to what my learned friend had to say, and really what the tribunal had to say in relation to that is, first objection is, once again, a question of standard. It's one thing to say, well, we can't say now how many people read it, how fully did they understand it. What is the standard that we are being held to in terms of communications? And why is it said that it matters whether we did or didn't spam all of our users with emails or whatever else it might be?
But isn't the boot on the other foot with this? Isn't it? Aren't you saying the tribunal could and should have decided now that what you did was on any view enough, and it was irrational to say otherwise?
My lord, that's right. It's entirely fair. But in answering that submission that we put to the tribunal, what the tribunal needed to say is, well, what kind of evidence is there going to be at trial, or might there realistically be a trial that's going to put all of this in a different light? I'm still entirely at a loss as to what it is. We know what the press coverage was. We handed up a bunch of examples to the tribunal at the hearing. So that's all known. We also know that it's obviously not the case that everybody read it, because not everybody reads the news.
But have you pleaded yet?
We haven't pleaded a defence.
So you'll plead in your defence what we did in December 2017 was enough.
Yes.
And they'll reply.
Well, my lord, we've already had that process, not in pleadings, but we made this point in our strikeout application at the tribunal, and we had their response to it, which was just what you've heard.
Sorry, but the question of saying, well, what, in a sense, what more could you have done? Or why isn't it good enough? What's the standard?
It's the second question, not the first. It's not what more could you have done. Is it why is it said, and how is it properly arguable at trial, that it was an abuse of dominance not to do more to disseminate this information?
Well, no, it's just that the abuse of dominance, the effects of the abuse of dominance continued, notwithstanding what you did.
No, it said that the abuse continued. That's the plea. That's the plea that we're trying to strike out.
As the effects go on the abuse. I mean,
it's not just a question of causation and loss, because actually the loss was suffered is said to have been suffered back in January.
So
it's the abuse.
So which?
Selling devices after December 2017 was said to constitute an abuse of dominance because we had only put the information that we put into the ether and had not done more to disseminate it. I just don't understand how that argument is said to be runnable at trial, particularly consistent with the rest of their case about how terrible these devices needed to have been. So that's really what we say on ground 3. Now, I accept your Lordship has fairly characterised the nature of my predicament in advancing that, both here and in the tribunal. But there is a summary judgment jurisdiction for a reason. It's not that all questions of fact have to be left for trials. That's not the law.
But it hasn't ruled that out yet.
But look, you can always say there will be more, because there will always be more, right, at trial. And so, but at some stage, one does need to grasp the nettle. Otherwise, essentially, what one is saying is that because there can be more, nothing can ever be struck out. And there's not going to be anything more on this topic. I don't know what further disclosure one anticipates receiving on this issue, however you characterise it.
Let's imagine something highly unlikely. There was an internal email which said, let's disclose in this manner because nobody will see it, exclamation mark. But I mean, I'm just saying theoretically, there could be disclosure on that issue, which could be probative. I'm not suggesting for a moment that that's what did happen.
My Lord, I do say that, with respect, that is really in the realms of fancy. It really is. I mean, this material, unsurprisingly, as I said, instantly got transmitted through all the major news outlets. What Apple does is...
But then there may be internal disclosure saying, if we send it out in this relatively nondescript way, we have no doubt whatsoever that it will immediately go viral. So therefore, we don't have to bother sending it out to X million emails or text messages. So that might be highly valuable to you. They'd be exculpatory to you.
That's right, it certainly would be, my Lord. But my point is this. In order to decide that this needs to go through further, your Lordship or the tribunal needed to rationally form the view that there was some prospect of the other kind of evidence coming out. Because if the only further evidence one anticipates is evidence that supports my case, well, you don't need that. It only makes sense to leave it to go to trial if you can actually articulate some reasonable expectation that there is going to be evidence that is capable of supporting the allegation.
I understand the point. I mean, the tribunal was the view. It might go either way. They couldn't form a definitive view as to which way the disclosure would go.
Yes, and my submission is that when it reached that conclusion, it fell outside the bounds of reasonable...
Understood.
In light of all the points that I've made. And I think sometimes if you have to identify what went wrong here, and one can't get in the minds of the judge, but sometimes it's a failure to see the wood for the trees. And that's why I told the story at the outset. You need to see all of the arguments together, including the connection between the strength of feeling and dissatisfaction that the consumers must have had from a learner friend to have a claim at all, and then the submission that somehow these consumers would not have been aware of what Apple said about their dissatisfaction in December 2017, despite it being all over the internet and the news. I mean, that's really, in a nutshell.
Sorry, something I hadn't, quite late to raise this point, but something I hadn't appreciated. The relevant period for the purpose of this claim is apparently still running.
But my Lord, that's right, because they don't, although they can't identify any information that is not still that is not out there about this, and it's not alleged that we're still concealing anything about this. The allegation is just open-ended, and you can see why they need to do it that way, because as soon as you accept for a moment the proposition that at some point people knew what they needed to know, and you ask yourself, well, what further information came out? The only date that makes any sense there is December 2017. The case after that point really does just become hopeless. That's why they put it that way, my lord.
The comment I've had from my lord is get lunch.
There's some sympathy for that view, I think.
It won't surprise you, we're going to reserve judgment. It will be communicated in the normal way. When we communicate it, it's not an opportunity for rewriting, re-argument, but we welcome all editorial corrections and comments as ever, and we will almost certainly produce hand-down in electronic digital form. Of course, nowadays on the front of every draft judgment there is the contempt warning, the warning about ensuring that it only is relayed to those who are authorised to receive it, and I'm sure everybody on both sides will be acutely aware of that. Can we thank you both very much for this, which has been surprisingly interesting, even though we've dealt with it at breakneck speed.
But my lord, I would just like to thank both of your lordships and also the court staff and also the transcriber in the ether.
Does the order for confidentiality need to be extended?
Yes, the order for confidentiality will be extended.
I'm just trying to find out where it is.
Until probably further order, which will then, when you see the draft, it will almost certainly be appropriate for you to agree whatever consequences there are to be agreed. And it may be we will seek your advice and views on what we do about confidentiality in the light of whatever we say about it.
Yes, and my lords, I take it that the order is extended both temporally and in its scope of application to the additional documents. So my learner friend's skeleton for today and also the physical copy of the CMA letter that we have.
If we miss anything out, you can correct it.
Well, I think what would be useful is could you agree a form of order
for that,
for that and send it to my clerk? Since I was the one who made the order, and I'll deal with that.
I'm very grateful.
But if you could agree the form of order to at least hold us over until further order, which will be following the handing down of the decision.
Understood.